February upon notice to the state respondent. Now that matter, when the wires of the Murshidabad state has been challenged and the interim order is expiring on 30th April, my lord had directed this matter to appear in the this week, my lord. So my lord,
It's not appearing?
no, my lord, it's not appearing, my lord.
Give the number.
My lord, with great indulgence, my lord, the one urgent
lordship.
matter of a list, group 7 item, group 7.
Yes.
This is though it is Jalpaiguri's matter, but the bench is, my lord, taken up. Lord, due to urgency, my lord, this matter will kindly take.
Jalpaiguri bench will commence on Monday.
But before that one, I try my level.
Urgency.
Urgency, my lord, the lack of the permit lack of the time of the bus cannot reply. That is my urgency in this matter.
Today we are already on Wednesday.
My lord,
By the time you serve at the Jalpaiguri circuit so that the matter can be
Well,
taken up on Monday.
service has been already affected, my lord. Kindly, my lord, taken up.
For these 2 days, I'll not take up circuit.
Well, only
matters.
1 second, my lord, the 1 second matter.
Take 1
Very,
second,
very
but the
short
circuit
matter.
commence on Monday, so I will not take up circuit.
My lord, the very short matter.
Shantanu immediately party then circuit.
Your Lordship's kind indulgence to
with
maintain.
regard to one contempt application, if your lordship kindly permit me, let it appear any day subject
What
to
is
your
the urgency, sir?
urgency, my lord. There was a direction by your lordship in the month of December to dispose of the representation within 8 weeks.
That is not being done.
No, they have not given any intimation, nothing. They are sitting idle over the subject matter.
You should have come up on in contempt.
I have filed that. That is why I am praying, let
This
it
is your
appear.
contempt application?
Yes, it's
Give
contempt.
the number.
Deeply
Your Lordship's kind indulgence, my lord, upon notice to other side, my lord, I'm mentioning one matter for extension of interim order. I've enclosed the server copy of both the matters, my lord. I have served notice also upon other side.
May I have your lordship's kind leave, my lord, for mentioning a matter which is WPA 11018 of 2020. We have filed an application for addition of parties. The notice has already been served on the other side. The connected matter is appearing tomorrow under application. So my most humble prayer is if your lordship would take these two, club these two matters. Grateful, grateful.
With regard to item number 168 to 174, my lord, these are appearing in your lordship's list. Now, my lord, here I am mentioning with notice, my lord. Urgency is this, my lord. Way back in December 2022, my lord, this hand auction was, my lord, that was done. My lord, we are the successful bidders. We are ready and willing to deposit the fees. Now, my lord, in relation to other blocks, my lord, an interim order was granted by your lordship's court, my lord, wherein we are not the party. Now, my lord, here, my lord, the stacked materials, my lords, are going to be eroded because of the ensuing monsoon. Now, my lord, if your lordship kindly takes up the matter, my lord, on Monday, subject to convenience of my lord, then, my lord, I can, my lord. Otherwise, my lord, the entire proceeding, my lord, will be stultified. The purpose of, my lord, the conducting, my lord.
Give the number.
I am giving, my lord. I'm extremely grateful.
My lord, may I be permitted to mention 5 matters, my lord? My lord, earlier, this is the 3rd time, my lord, I am mentioning these matters. It is in the item numbers are 663, 639, 638, but the matters are not coming in the list, my lord. And
They are in the monthly list.
yes, my lord, monthly list.
What is the urgency?
My lord, it is a short-term mining lease, and my humble prayer is to only consider the representation matter. Grateful, your lordship.
Number, will you mention on Tuesday, because Monday is a monthly list day? So if you mention today, it will again go into the monthly list on Monday. So why didn't you mention on Tuesday? I'll take it.
Okay. Grateful, your lordship.
My lord, may I permit to mention one matter, my lord? This is the restoration application, my lord. Okay.
My lord, mine also restoration application. Lord, may I beg to my lord, the exchange of affidavit is complete, my lord, as per the direction of this law. Yes, lordship, the matter is senior citizenship matter, my lord, the land. Lordship, not hearing, my lord, it's in the motion stage. Lordship, yeah, in spite of that, it was kept in the motion stage, my lord. It is a senior citizen matter and the property has been taken in the year 1966, lordship.
The number, please.
My lord,
But this is on the, but this is also month list matter, my lord. But the private restaurant made an illegal construction in front of the petitioner house.
My lord, May I be permitted to mention two matters, my lord? This is relating to short-term mining lease. My lord, only last week, it has been mentioned, and as per your direction, it should be in the list, but it is not appearing in the list.
The number. Please call the
Grateful lordship.
Jalpaiguri Circuit.
Jalpaiguri Circuit Bench Matter, item number 1.
Yes, my lord. For the last occasion, you have to write Mr. Day. I handed over the copy of the order which sent to me, directed to file a compliance report. But let compliance be filed.
My lord, in this matter, my lord, we have already complied and given the order to my learned friend, my lord.
I have shown to your lordship, my lord, through my WhatsApp. They sent a copy of the order. Your lordship have gone through the, then your lordship, after going to submit a compliance report.
Then, my lord, your lordship can fix.
Yes.
Service.
Oh, efficiency.
My lord, he will come from Jalpaiguri. Only for that reason, my lord, say, we have already complied the order.
Yeah, I know he has no respect. I repeatedly requested him. I sent a copy of the order. Alright, he intentionally did not pass the order within time. Specifically, your lordship fix your lordship order.
Service. Paragraph learned counsel for the alleged contender seeks to submits that the order seeks to take it. Submits that the order under contempt has been complied with. Stop. He seeks to submit an affidavit of compliance on that agenda. Paragraph.
Not within time, but I sent notice to him. The time has already expired. You are sitting tight over the matter.
15th May, sufficient.
Sufficient time, my lord. I need not want sufficient time. My lord. Your lordship can fix the matter next week, my lord. As you can comply and he will come, my lord. Yes, my lord.
4th May, I shall not be here. I shall go to the circuit bench. But that,
Let it be 15th May. Because
Yes,
15th May, 15th.
circuit is there till the.
Yes, yes, yes. 15th.
15th. Regular bench matter, item number 1.
এই আমার নাম তো দিল না। আমার নাম দিল না।
Respondents, my lord. The respondents have not sought renewal of the lease period in terms of the Act of 1976 or otherwise, and have been possessing the property in question without having any legal right therein. As discussed earlier, the respondents cannot be said to be in settled possession of the premises on acquiescence on the part of the petitioner, since the petitioner has neither assented to the possession of the respondents nor accepted any rent from them after expiry of the lease. The respondents therefore have no alternative but to deliver peaceful vacant possession of the premises to the petitioner within 3 months from this date and pay arrears of market rent to the petitioner from 1st January 2006 till the date of delivery of possession in favor of the petitioner. In the light of the discussion, the writ petition succeeds. The respondents are directed to deliver peaceful vacant possession of the premises to the petitioner upon removal of the structures thereon within 3 months from date. The respondents are further directed to pay arrears of market rent to the petitioner in respect of the premises from 1st January 2006 till the date of delivery of possession in favor of the petitioner.
Item number 2.
Down for the petitioner.
নম্বরটা অ্যাডভোকেট জেনারেল তোমাকে দিয়েছে বলে? না, 2 নম্বরটা। আমি তো 3 নম্বরটায় আছি। দু নম্বরটা অ্যাডভোকেট জেনারেল তোমাকে দিয়েছে।
যাই হোক, my lord,
তোর কাছ থেকে নিয়েছে, এই তো।
they have a, my lord, interim order that your lordship was pleased.
My lord, my lord, I am strongly objecting so far extension of the interim order concern. Kindly hear it out right now. My lord, because,
Business.
my lord, yes,
But it takes
if,
to hear it out just
if,
it's fine for
my lord, kindly consider one thing. Unauthorizedly, my lord, they are occupying the premises.
the heard of the matter.
My lord, kindly fix it on any date, my lord, kindly at 2 PM. My lord, because this is a government property, my lord, it is a, my lord, I will satisfy. My lord, everything is on record.
Mr. Sengupta is, my lord,
No, my lord, everything is on record. My lord, kindly see, my lord, the affidavit, my lord,
Heard learned counsel for the parties.
but kindly fix it
my
up.
lord, kindly please, no, before vacation. No, you have some difficulties, engage another.
No, Mr.
No,
Sengupta,
no.
I can't.
You cannot
You can't
dictate,
dictate the code like
you
this.
cannot dictate the court.
It is my prayer before the court.
My lord, time, yes.
Decorum
my lord,
dictates
he is, my lord, he is dictating the
Don't say
court.
he. Don't say he here.
Then, who is you? তুই তাকে সি বলবো?
21st June.
21st June, my lord.
One. Heard learned counsels for the parties.
My lord, kindly, I am beseeching to my lord, kindly hear out the matter. Oh, all right, my lord.
Have you completed?
My lord.
Let the matter appear under the heading Group 1 hearing on 21st June 2023, paragraph. The interim order granted earlier is extended till 31st July 2023 or until further orders, whichever is available.
My lord, at 2 PM, my lord, kindly fix it at 2 PM. My lord, this is, my lord, this, my lord, this is going on for the last 6 months. No, my lord, I cannot, I am not sick. My lord, kindly what I am on. My lord, kindly, I am humbly submitting, my lord. This is the property of the, my lord, the hospital. And my lord, they are unauthorizedly occupying that premises. My lord, kindly fix.
No, my lord, kindly.
I am not seeking for, I want to know what I am on, but kindly, my lord, I am making one humble submission. My lord, I am making one humble submission. Kindly fix it at 2 PM.
My lord, similar matter, my lord.
That's same. My lord, only thing, my lord, kindly fix it at 2 PM. I am beseeching to my lord.
Court is appearing.
I am for the petition, madam. On the last occasion.
My lord,
Please,
take something. Matter, my lord, I am appearing for the private respondent. There is the interim order is there. I have filed our opposition, my lord. So, if your lordship.
আমাকে বলতে দিন, আপনি তারপর বলুন না। But I am for the petitioner for Holden municipality. Your lordship was please last occasion. Your lordship was extend the interim order 30th April. I am for the petition. Well, they are sub opposition. I have misplaced the copy. Again, I have collected one copy. I shall give you reply. Your lordship kindly fix it any date. Within a week I shall sub the reply, and your lordship kindly fix the date to hear. And the interim order is expired on
This is
30th
the
April.
unauthorized occupation under section 10(4), my lord. Up to appeal fought out.
I shall satisfy your lordship, my lord.
This has come, my lord. And fix up any date because it is now, my lord.
I shall satisfy your lordship at the time of it.
June has.
No problem.
And আমাদের ভিডিওটা ফাইল করে দিয়েছো?
আমি কপি করে ফেরত দিয়েছি যে সব।
Heard learned counsels for the parties.
And this is our affidavit of opposition, my lord.
Affidavit in opposition. On behalf of the state respondents is taken on record.
Well, not state, I am to the private respondent.
Already filed, my lord.
Private respondent is taken on record. Paragraph. Affidavit in reply is yet to be filed. Paragraph, let the matter appear under the heading Group 1 hearing. Monthly list of June.
No one did any date, my lord. Only one thing. 4th or 5th, any.
The middle of June, my lord.
19th June.
19th.
19th June. Paragraph, the interim order granted earlier is extended till 30th June or until further orders.
Get my lord. Interim order is there, my lord. You cannot oppose what is.
Someone here.
Yes, my lord.
Item number 5.
Madam, a small correction, my lord. Ordering person.
What's the correction?
But
Correction required.
well, instead of respondent 5th, it should be 4th, my lord. Last 4 lines.
কবে আসবে
So there is appeal.
লাস্ট ডেটটা কবে আসবে?
Thank you.
Yes, my lord. Your lordship.
Illegal listed.
So
Only
this
that
four-
question.
four Executive engineer.
Quota correction church.
Respondent number 4.
Respondent number four.
The matter has come up under the heading to be mentioned at the instance of the petitioner, paragraph. That error has led to the order passed on first. Paragraph said order. In the
Only that question.
fifth and sixth paragraphs of the said order, comma. The fifth respondent be read as
Fourth.
the fourth respondent. Paragraph, the department is directed to incorporate necessary correction in the order. Accordingly, paragraph, this order be treated as part of the order passed on 1st February 2023.
ये कागज गुलो.
Number 6. Six, Lord, I am filing my exception to the affidavit of compliance, my lord. I served then today in the morning, lord, because couldn't serve it
I
earlier.
appear for the alleged contempt.
Need some time to go to the next.
I'll be requiring some time, my lord. I was requesting, my lord, but there is nothing in this contempt application. It could have been dropped subject to your lordship's kind sanction, my lord.
Cannot be dropped because
But my
specific-
learned friend insists that I have not complied with the lordship's order. Now, this is with regard to, my lord, the granting of mining lease. Whether Maharaja of Burdwan had given a mining lease, had taken out a review application, lordship was pleased
review
to
was dismissed.
dismiss, my lord.
And they,
And in the review application, my lord, lordship was pleased to observe that the proposal of the block land and land resource. I'll come back, my lord, on the next day. I'll come back on the next day.
Exception used by the applicant petitioner to the affidavit of compliance submitted by the alleged contemner is taken on record. Paragraph, on prayer of the alleged contemner, the matter is adjourned. Let the matter appear on 16th May.
16th May. 16th.
much obliged.
Much obliged.
Seventeen.
17.
Item number 7.
I am for the petitioner, my lord. I am for the applicant, my lord. On the last occasion, my lord, so caused the, my lord, the contempt. Why they are not complying the order of the, my order of my lord.
My lord, I am filing, yes, my lord. I am filing the, my lord, affidavit to complaint. In this matter, my lord, the principal secretary is not a party of the proceeding, my lord. In spite of that, my lord, principal secretary, he filed a contempt application against the principal secretary.
No, my
The
secretary is the party, my lord, in the petition. My lord, secretary is the party.
Principal secretary is not a party. Secretary, principal secretary is not the same.
Second respondent.
That is secretary.
Secretary, my lord.
Second respondent is, my lord, in my compliance report, my lord, I have annexed the first item.
My lord, so after passing of this order, my lord, I have communicated the order. Thereafter filed contempt notice, my lord. Upon filing of the contempt application, my lord, I am also serving them. They are never taking this plea that the secretary is not the principal secretary. Let them name the who is the secretary, who is the responsible for the contempt proceeding. The
No, my lord,
secretary.
yes, principal secretary is not the principal secretary, my lord. If your lordship will see my compliance.
My lord,
Secretary, my lord, compliant the order, my lord.
as per
In
the,
spite of that, my lord,
my lord's order in page 18, my lord. My lord directed them to comply the order within 2 months, my lord. Already, my lord, 10 months have been passed, my lord. And I am,
Has it been complied with?
no, my lord,
my lord, your lordship.
not
I-
a single penny has been paid, my lord. Already 22 years passed, my lord.
I have annexed the order of the secretary, my lord.
You have in fact wrongly implemented the business now.
My lord, the order passed by, let my lord, let they tell who is the authority, my lord, name.
My lord,
I
secretary-
will see who will face the contempt, my lord. I have communicated to the secretary, my lord. I have communicated to the name of the secretary. 5 times communication, they have not replied anything, my lord. Every record is on the, my lord, on our own court record, my lord.
My lord, your lordship. knows
After
the-
passing of the order, my lord, as per your lordship's order, my lord, I have communicated to the secretary, my lord. My lord directed them to comply the order within 2 months.
But secretary has in fact taken necessary steps for compliance of the.
My lord, kindly,
The-
just now, my lord.
Will you go through it and come back?
My lord, kindly think, my lord, I am not getting a single penny for that, my lord. Not a single penny till now.
It's not the authority to give you the amount.
Secretary is the,
This is a question of direct purchase.
Yes, my lord.
Several other authorities are involved. As
No,
we
no, my lord.
discussed this matter
my lord, this is thing, my lord, if we go to the main writ petition, my lord, every letter, they are making letter to the secretary. That's why my lord directed the secretary. If my lord go to the page 41, my lord, on the basis of my lord pass the order.
Page 12 of the integrated compliance, the decision part.
Wait.
They have agreed to your proposal and they have processed it.
Just a minute. My lord, page number 12, decision part.
The decision part, yes.
After hearing the matter, assessing the pros and cons on the basis of the documentary evidence as placed before the undersigned, after due consideration of the memo number such and such, the chief engineer, it has been decided the necessary step will be taken. The government of irrigation, no matter in terms of the memorandum, so read with such and such. Diapers of the piece of the plot involved, necessary formalities subject to approval, reputation, and the state can then after verify the president, the subject in my lord directed them to comply with 2 months, my lord. They are passed the order after 4 months. That was not. Well, where is the time limit, my lord? My lord specifically says it should be within 2 months. I have communicated it. They received it on the 7th of July. After 4 months, they are just passing the recent some order, my lord. I have served the order to the secretary also, my lord.
A joint field verification was done as pursuant to this order.
My lord, they are told the petitioner to come before this irrigation department in the, my lord, in Salt Lake. He came 6 months ago, my lord. And my lord, I have communicated the order on the, my lord, 7th day, and they received on the 7th of July. 2 months, my lord, to the secretary also, my lord.
They're kind of explained the delay in the.
And my lord directed them to crystallize the petitioner land as well the payment of the amount due to the petitioner within 2 months, my lord.
But I'm afraid the secretary is not the authorities, not the authority.
My lord, everyone wrote letter to the secretary, my lord. In the writ petition, if my lord goes to the writ petition, my lord, everyone wrote letter to the secretary. Everyone, the ADM, the engineer, the chief engineer, everyone wrote letter to the secretary to take necessary steps. Then who will, my lord, the authority? The secretary, everyone wrote letter to the secretary. If we go through the writ petition, if my lord, my senior friend, Leonard's senior friend has copy of the writ petition, my lord, we'll go through everyone wrote. My lord, this is a case of 2020 to 2001, my lord, 22 years already lapsed.
The relevant fine is pending for getting of estimate by the before the land reforms and refugee rehabilitation department. It has been sent by the irrigation department to the refugee rehabilitation department.
But my lord,
Section R3.
if my lord come to the writ petition, my lord, in every page I have annexed from the last 5 years, my lord. If
But my learned friend never said why in place of respondent number 2, why principal secretary was in the contempt application.
No, my lord.
I can't understand.
We send the secretary.
I can't
The
understand.
secretary is, my lord, if
Being a lawyer, you must
no,
say
my
why.
lord, page 41, my lord. There is no designation whether he is a principal secretary or joint secretary or non-secretary, nothing.
You have.
Yes, my, it is their letter, my lord. It is their letter. Page 41, writ petition. They have communicated to the chief engineer, recorded to the secretary. If every person is the secretary,
The secretary, but you have included the. In the
my lord,
contempt,
we send notice to the secretary. We send, when we send the notice, it is the secretary. Then we collect the name, then
The contempt application is wrong in that case, sir.
my lord, then my lord, I will change the name of the person who is not now is who will face your lordship's contempt, because I have communicated the order to the secretary, my lord, as per your lordship's direction. I've served them on they receive it 7th of July, my lord. Then, my lord, my landed can give me the name. He will face the contempt, my lord. Name can be changed.
মিতাল ওটা দেখোই নি, ওখানে তো নিচে নাম দেয়া আছে, দেখো না কেন দেখছো
এখানে
না?
তো এখন দিলেন।
তখন থেকে আরে এখন দিলাম, এখনই বলো না, তুমি ওইটা
My
দেখে
lord,
বলো।
I am incorporated the name of the Nayanjyoti Ghosh. He will answer, my lord. He is the secretary.
My lord, in spite of that, my lord, though contempt petition is, my lord, otherwise be bad, my lord, in spite of that, my lord, secretary, my lord, can do his duties, my lord.
But my lord, I have communicated order. They have not complied within 2 months. Nothing, my lord.
মানছের মতো হবে না।
No, no. From the last month.
প্রসিডিওর আছে, এটা তো অন্য জিনিস না, এটা প্রসিডিওরটা তো
Already 23 years past, my lord.
It's been faced in all the direct purchase cases because several authorities are.
Yes, my lord, we are facing trouble, my lord.
My lord, let they say who will face the contempt.
তো contempt নয়নজ্যোতি বলাই আছে তো।
Let my line go the name of the Nayanjyoti, my lord. Because I have served everything, my lord, served contempt notice, everything, my lord. They have never says anything upon receiving the same. In my contempt application also, my lord, communicating the same. I annexing the same.
In the first place, contempt application has to be withdrawn and filed afresh. Technically. Because it is a wrong contemptor, you could not have brought him down to contempt.
Mother secretary, he is the name of the secretary, my lord.
Secretary and principal secretary are not the same persons. All throughout in the writ petition, you have stated secretary.
My lord.
Suddenly in the contempt application, you come up and say the principal secretary is
My
liable.
lord, I'm praying liberty, my lord, who is the
Because you already served notice. You have to withdraw and file afresh, number one. And secondly, in spite of that, the principal secretary has filed a report.
but my lord, we have served them, they are never saying.
No
When they
mandate to file.
My lord, when they receive the notice from the several location, my lord, they have never communicated anything to us. We served them several locations by notice.
It's not for them to communicate. It is for you to.
My lord, from the secretary, when we served the secretary to notice, my lord, prior to contempt communication the order, they have said nothing, my lord.
The secretary is the proper person. That's why they have said nothing. In the contempt application, you have suddenly said principal secretary. Prior to that, it has been secretary all throughout.
Yes, they are no one. This is the first occasion, my lord, they are communicating anything.
Yes, because this is the first occasion you have received the principal secretary.
My lord, we are also communicating lordship.
Secretary.
We are communicating the order to the secretary also, my lord, your lordship. If my lord directed us, my lord, let the secretary should be part as a party, my lord, in the contempt process.
You have already served and a show cause has been issued wrongly on the basis of your application. This is not correct.
Well,
You have impeded a person who is no way responsible.
But my lord, in the every occasion when it is shown in the internet, my lord, the Islamic name is internet shows as the secretary of that, my lord. That's why we have inquiry, my lord, from the
Person is shown as secretary.
secretary. When we search for the secretary, his name is the first position. That's why, my lord.
Now clear that he is the principal secretary. and
Yes,
not the
yes, my lord. Then, my lord, if my lord direct,
দিন ওখানে আছে তো, তুমি এবার ওই এগেইনস্ট একটা করে দাও, তাহলেই হয়ে গেল।
then my lord, we going to the again, my lord, file.
My lord, within 1
Already
year, my lord,
22 years already elapsed.
First on June 27. Up to 26 June, he can file contempt application. He can withdraw this application and file a fresh, my lord.
Or there is another alternative, if I can dispose of the contempt application, because the secretary has paid his part.
No, my lord, the amount is not done, my lord. There is a direction for the amount, my lord.
Taking necessary steps for the amount which the secretary has taken. Please come to the order under contempt.
My lord, in view of the above, the petition is disposed directing the second respondent to consider the case of the petitioner in terms of the communication made to him by the chief engineer Tista Barrage project on 28th June 2018 and take necessary steps for crystallization of the proposal for direct purchase of the petitioner's land, as well as payment of the amount due to the petitioner within 2 months from the date of communication of this order.
Necessary steps for all this. He has considered your application, your representation and has taken necessary steps.
Not within 2 months, my lord. Not within 2 months, my lord.
That's why you came up in contempt.
Yes.
The order has been substantially complied.
Partially, my lord, no amount has been, regarding the amount part, my lord, they have not taken.
He was directed to take necessary steps not to pay the amount. Necessary steps to crystallize the proposal and payment of amount. He has taken the steps. So it is substantially complied.
But my lord, no payment has been made, my lord.
The submission.
Yes, my lord, I'm repeating, my lord, because my lord, the
He was not to make any payment. He was supposed to take necessary steps for payment which he has taken.
My lord.
So it has been substantially complied with.
But regarding the part of the delay, my lord, they have not taken anything, my lord, saying. And my lord, one thing, my lord, then who will, we are taking stays, my lord, the person already, my lord, as a my lord, 22 years already, they have acquired the land, my lord. They are not giving the single money. If more than 5 or 6 years go, my lord, the petitioner already in the
What
session.
further steps can you expect from him? Seen the report, or do you want to go through the report and come back? The order clearly says that it has been forwarded, it is waiting for vetting. It will be vetted and then funds will be placed. That's the procedure.
My lord,
Direct purchase is that there are several authorities who are involved.
my lord,
Sometimes it is even before the cabinet.
Ma-
So the secretary will have little role to play there.
but there is no time limit when they will give, my lord, already 1 year has passed after your lordship's passed order. Something, my lord, something, he is coming after 23 years, he is fighting for his, my lord, land. 23 years, my lord.
The state cabinet is also involved.
My lord, 23 years, my lord. When he will get the payment, my lord, of his land? It's not a 1 day, 2 day, my lord, 10 years, 12 years. Only my lord, 23 years passed.
You should have included all these persons as parties in that case. When the order was passed, it was only on the secretary.
Yes, my lord.
The secretary has played his part.
The
He is not the person to vet the.
Because, my lord, everyone wrote letter to the secretary. That's why, my lord, we are placing this before your lordship.
But now you find that the scenario is different.
The secretary only, my lord,
Whatever the secretary has done, he cannot do anything beyond that. Now it is for the refugee rehabilitation department and the cabinet.
my lord, the other person's name are not there, only joint secretary is there, my lord. Other persons are not, my lord, in the report, my lord. Also. My lord, only joint secretary and, my lord, the other, all persons are already, my lord, except the special land acquisition officer, all are already made party in the writ petition.
The writ petition.
My lord.
But here I find have you implemented the refugee relief and rehabilitation department?
No, my lord, there is a not be part up to 2022, my lord. There is no role of them, my lord, in any letter, anything, my lord, any place. This is a new fact they have, my lord, brought before this lordship. Because prior to last one,
An exception you can. Because in any event, this person is not responsible.
no, my lord.
Still, he has filed a report.
Yes, yes.
Yes.
If my lord direct me, if we file, can my lord be the new person be implemented as a party because the name was the different, if possible, my lord. Or my lord, my senior learned says, let the contempt maybe wait for some time so that the payment may be done, some payment may be done.
Can return file a press if he wants.
So since you have already.
My lord,
filed
a person who is not the writ petition, he will, my lord, with the
But he
contempt.
has already.
My lord, there should be a proceeding that money should be paid by the petitioner. Then, my lord, it will be stopped. Otherwise, my lord, I am not a party of the writ petition. How I can be a?
Why did you file the report then, Mr. Dev?
Yes, my lord, as because my lord, that is I am implemented as a contempt. So we must file, my lord, according to the court
My lord,
order.
when we
must file
serve
the
notice, my lord,
comply.
if the or say principal secretary communicate us for a single time, single location, last 6 months we have
তার জন্য
changed.
কি তার PK contempt
No,
দিতে হবে?
simple communication that I am not the party, someone different party. My lord, maybe
Why did he make such communication? Because he is no way responsible. He has no
I
liability
understand.
whatsoever. Mr. Dev, how long should we wait for this?
My lord, your lordship, so many cases there, my lord. Vetted after that, my lord, we will give the notice to the principal secretary finance.
After vacation?
My lord, this petition is not maintainable. I say, my lord.
Please
Now,
come.
my lord, he is wanted to say everything, my lord, 22 years, 23 years, but this petition is not maintainable.
well, I file by tomorrow, my lord, new writ petition. I am discussing it.
Yes, my lord.
Let
He
he
can-
will face
he
the
can-
person will face the contract.
My lord, proper
Because the
application.
state is such a position that, my lord, I am 9 months, last 9 months, I am a communication, the order to the principal secretary. He have nothing communicated to us. Even my lord, I have communicated the secretary as per your lordship order. After 4 months, they are passing the order, my lord. They deliberately violate your lordship order. My lord, I am withdrawing it, and by tomorrow, my lord, filing the case, and he will face the contract. It is deliberately they are facing the contract.
Affidavit of compliance submitted on
Because
behalf of
no new contempt application, maybe my lord, the new contempt notice should not be given.
Principal Secretary, Irrigation and Waterways Department, Government of West Bengal, is taken on record. It is submitted that the Principal Secretary was not included as a party respondent to the writ petition and is not the alleged contender herein. Paragraph. It is a fact that the order under contempt directed the second respondent, who is the Secretary, Irrigation and Waterways Department, Jolo Sampad Bhavan, to comply with the order passed on June 27, 2020. Stop. The said respondent has not been arrayed as a contender in the contempt application. Paragraph. Learned counsel for the petitioner seeks to withdraw the contempt application with liberty to file a fresh application on the same cause of action.
Madam.
Paragraph. Such liberty is granted. Paragraph. The contempt application being CP and such is dismissed as withdrawn. Paragraph. There shall however be no arrest costs as the secretary process.
Madam, deeply obliged.
Dismissed as withdrawn.
Deeply.
Next.
Item number 8. This is my application for contempt of your lordship's order dated 29th of September 2022.
Appearing for the first.
For the first time,
Sir,
as a lordship, kindly but give a date before the vacation.
for the vacation. The applicants are directed to serve copy of the contempt application along with annexure thereto upon the alleged contender and file affidavit of service on the adjourned date. Paragraph. Let the matter appear on the same heading on 10th May.
10th. Much obliged.
At number 9.
9 clear. Affidavit of service I appear for the petitioner lordship in this matter.
Have you served?
Yes, my lord, they are appearing.
But I am happy. State.
It is no. Lordship, I had come earlier before in the writ petition, and your lordship had passed an order in page 31 is the order of your lordship.
Give me a minute, please.
Huh?
Give me a minute, please. I'll just see this, check this.
Page 31, my lord.
31.
Page 31.
Give me a minute, please. I'll just check the service. Oh. NHAI, Union of India, no one. Divisional Commissioner Hospital, who is this? The state,
State.
Divisional Commissioner?
State.
That is a arbitrator, my lord. Appearing on the state.
He's the officer of the state.
In that case, may I request Mr. Day to appear in this matter? Please serve him a copy of the writ. Yes, what is the matter?
Lordship, this is the acquisition of the land in by the national for the national highway. And Lordship, I had come earlier before this court, and your Lordship had passed this order in page 31.
The operative part is in page 32, Your Lordship.
Yes.
The district magistrate and collector appeared before him. He had given me notice, but he did not change his earlier order. He kept this order saying that the present market value cannot be given to me, and the excess land which has been taken, that is to be considered by you make the representation before the national highway. Now,
Where is the order in queue?
order in Pune is starts from page 33, Your Lordship.
This order has been assembled in the petition present.
Lordship, I am wanting a direction. I have gone before an appeal before the arbitrator on last year. The arbitrator has been sitting with the proceeding and not giving me notice, nothing. I want a direction that the proceeding should be disposed of in a time frame. That is prayer C of this writ petition, Lordship.
Well, the petitioner's prayer is, Lordship, to grant the compensation as per the present market value, my lord. Well, my lord, the statute says, my lord, from the date of publications, my lord, not from the present market value, as per section 3G7. My lord, my lord. Well, only, my lord, the statute says so, my lord. The statute says so.
যেটা হবে in accordance with it. হ্যাঁ না
You preferred an appeal against this order.
Yes, sir.
15 June order.
And that is in page
3G5, my lord, that is in that down.
Page?
Now, my lord, you will consider and
that is in page 37. I have applied to the arbitrator, Divisional Commissioner, West Midnapur.
My lord, that is his prayer number C, my lord.
Prayer C is
3G5, yes.
To dispose of this appeal.
Disposal of 3G5. So let that be done.
yes, ma'am.
Affidavit of service. None appears for the state respondents despite service. Their service.
আমার নামটা লিখে চালিয়ে দিতে পারবে তোমাকে নৌকা বলছি
So I get a copy.
এটা কপি
আপনার নামটা রিপোর্ট
না না যশোর পড়ছি
An order passed by the district magistrate and collector Purbo Medinipur on 15th June 2022, the petitioners filed an application under section 3G5 of the National Highways Act 1956 before the learned arbitrator, being respondent number 3,
respondent number 3.
being the third respondent hearing, which is yet to be considered. Stop. The petitioners pray for a direction upon the said respondent to dispose of the said application within a stipulated time frame. Paragraph, upon consideration of the submission made on behalf of the parties, the writ petition is disposed of, directing the third respondent to consider and dispose of the application submitted by the petitioners, by the appeal submitted by the petitioners.
Before the divisional commissioner, before the arbitrator, kindly record.
The third respondent will dispose of. Within 2 months should be sufficient. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioners, in accordance with law. Stop. It is needless to mention that the decision taken by the third respondent shall be communicated to the petitioners within a week thereof. Disposed of.
Lordship, in appeal oblique arbitration proceedings, because they are calling the
arbitration proceeding. That's why I'm saying before the arbitration. My lord, that is. Without going into the merit, my lord, I'm grateful.
It is made clear that this court has not gone into the merits of the case. And the learned arbitrator shall be at liberty to deal with the issue independently and without being influenced by any observation which may have been made in this order. I'm grateful, ma'am.
Much obliged.
Yes, next.
Item number 10, my lord, in item number 10, paying for not today, my lord. If service is not affected, paying for not today.
After petition.
After verification.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 12th June.
Number 11. My lord, item number 11. I'm appearing on behalf of the petitioner, my lord. From the state. My lord, this is the affidavit of service effected upon all, my lord.
You're appearing for the state?
Yes, ma'am. State.
What about the private people?
My lord, service affected, my lord.
Yes.
My lord, matter relates to the demolition of unauthorized construction. The private respondent number 8, without permission of the
There is no aid.
7. Without permission of the authority, by encroaching the public land, constructed the illegal construction, my lord, in front of the variety land of petitioner, my lord. Entire ingress and egress blocked, my lord. So, my lord,
This is the 62 Act.
62 Act. My lord, respondent number 3 is the authority.
It's very serious.
My lord, 44. Page 44, P2.
Can this be considered?
Yes.
Thank you. Yes.
No.
Of service. None appears for the private respondent despite service. Paragraph. Submitted on behalf of the petitioners that the private respondents have placed unauthorized construction on government land adjoining their property, thereby obstructing their ingress and egress. Stop. The petitioners submitted a representation in this regard on 21st February 2023, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the representation at the earliest. It is submitted on behalf of the state respondents that the SDO should be the
Yes, SDO is the authority. Respondent number 3.
third respondent be directed to consider the representation in accordance with law. Paragraph number of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months.
2 months, my lord.
There are so many steps under the 62 Act.
3 months. Okay.
Within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, with the petitioners and the private respondent in accordance with law and accordance with law. Suppose that.
At number 12.
Dear my lord, in this matter, my lord, I am appearing for the petition.
Of the state.
The prayer of the petition is for demarcation of the land from the acquired portion and the unacquired portion. If your lordship can turn to the notification regarding issued by the National Highway Authority, your lordship will find our middle column, my lord.
Okay.
Page, my lord, 13, P2. The middle column, my lord, 1, 2, 3, 4, 5, 6, 7. 15. 15 from the bottom, RS Dag number 1229, my lord, got it?
Yes. 1, 2, 3.
Total area subject matter acquisition is 0.0152 acres.
The entire land comprises of 0.18.
No, it is 0.18 acre. Page 12, P1. .18 acre. My lord, got it?
Yes. And 0.152 has been acquired.
0.152. So there are other parcels are there, their names are also been there, my lord. So I prayed for, because there is a dispute between because the entire plot of land which is acquired, along with the amalgamated the unacquired portion also. I made a representation to the authority, my lord, if your lordship can consider page 20, last portion. Because he is the competent authority, my lord, the additional district magistrate.
Compensation has been paid.
Yes. There is no dispute regarding the compensation. I paid the compensation. Huh?
Compensation is actually
Very rare. No, that is the other avenue. I am not concerned. So, আপনাকে অংশে বুঝিয়ে দেওয়া তাদের সীমানা নির্দেশের কারণে যদি সরকার নিম্নলিখিত কোনো রূপ অর্থ ওইটা তাই নির্দেশে প্রস্তুত আছি। So my condition is to demarcate the acquired portion from the plot of land in question. That nothing.
My lord can pass the order, my lord, to dispose of these representations.
That will solve your.
Yes, but demarcate.
Given all the details in.
All the details I have given, my lord.
But the demarcation will be done by the special land acquisition operator. They have made representation before the অতিরিক্ত জেলা শাসক.
The ADML competent authority. I have to approach the competent authority. There is no other option.
Demarcation.
No, it is only the consideration. They should take necessary steps.
Yes, because the special land acquisition collector under the LA Act, my lord, I can approach. But the National Highway Authority, my lord, is the competent authority, is the authority under the statute.
So it will be the special land acquisition officer.
My land, but under the statute, my lord, the ADMLR is the authority under the as a competent authority.
But ADMLR is the authority on ADMLR. Let me page 20 be considered.
Yes.
Page 20 may be considered.
Page 20.
For the councils for the projects. Petitioner claims to be a joint owner of the. Without in question. Number 129. Mouja Dhubulia. Tail number 33. Nodia.
Subject 1229 Shabik Dak. My lord can record Shabik. Yes, my lord, Shabik. No, Shabik Dak, my lord. LR is, my lord, 2991. In the I have annexed the record of rights, page 1.
First page, LR Dag number 1229. Shabik is LR.
Shabik. But here, my lord, is Dak number, Shabik Dak number is 1229. My lord, that's his.
First page, your writ petition.
Yes.
First paragraph, second paragraph.
1229.
Shabik. My knowledge was Shabik is LR.
Subject to, but that is why, my lord,
Present.
present. No, Shabik is Shabik, old, my lord.
Old.
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 RS Shabik.
And all is
Hal is LR. Yes. My lord, LR Dak number is, my lord.
Yes,
Hal. Portuan.
Hal the present.
But that is Shabik. That's why, my lord, in the I have annexed also the representation. Shabik.
Yes. LR is 2991.
And Hal is, my lord, 2991.
LR.
ঠিক আছে, সাবেক হলেই হবে।
Shabik Dag number 1229. We take a case number 28/NH/10-11. 0.015 acres out of the total land of 0.18 acres has been acquired by the state. The petitioner has prayed for demarcation of the acquired portion of the land in order to enable him utilize the remaining portion thereof. Stop. The petitioner submitted a representation in this regard before the concerned authority on 27th August 2019. It is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on the respondents that the third respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month.
Yes. Upon taking
2 months, because
2 months, the demarcation is necessary. Will indicate to that. Otherwise, a simple order will be passed. After that, I have to
within
again.
2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner, in accordance with law. Stop. The concerned authority shall take necessary steps for demarcation of the acquired portion of the land in presence of the petitioner / his authorized representative upon service of notice to the petitioner
Grateful to your lordship.
within the stipulated time frame.
My lord, after considering the representation, is it at all necessary, my lord, for the demarcations, my lord? And they recorded this, my lord, after.
If it is not necessary, my lord, the authority will not do anything. It is.
My lord recorded.
The authority shall
Absolutely. Yes.
necessary steps for demarcation of the land, if necessary.
Entire plot is 1.118. Acquired portion 0.0. Because under the statute, they are bound to demarcate the land.
Next.
Item number 13.
Both the petitioner.
Sir,
Yes, ma'am. My lord, earlier the petitioner, my lord, move on read petition.
No.
Earlier, my lord, the petitioner move on read petition before this.
stop the private respondent.
Yes, my lord.
Please try that.
Yes, please, please.
Not earlier the petitioner move on read petition before this honorable court, my lord, alleging unauthorized construction and illegal encroachment by the private respondent, my lord. And my lord, page 34, my lord, the Honorable Justice Sinha was pleased to pass an order and thereby directing the Pradhan to consider and dispose of the representation made by the petitioner relating to unauthorized construction. And after that, my lord, due to non-compliance of the order passed by the Honorable Court, my lord, the petitioner filed one contempt application before this Honorable Court. My lord, in a contempt application, my lord, the Pradhan came before the Honorable Court and my lord submit a report before this court and stating that the illegal encroachment and the unauthorized construction was made at a government land, my lord, PWD government land, and submit a report and stated that they are send all necessary documents before the appropriate authority for taking consideration, my lord. After that, my lord, I made a representation before the authority on 28/2/2023 for taking necessary action. They are not taking any step. After that, my lord, after filing the writ petition, my lord, they are complied with the provision of section 10(2) of the Highways Act, my lord, and they will serve upon 10(1), sorry.
So your grievance has been redressed?
Yes.
So
But
nothing further remains.
my lord, 10(1) has complied with, but 10(2), 10(3) has not been.
Let the proceeding be,
Yes.
concluded with the stipulated time frame?
Specific time. My report is there, madam.
You're submitting the report?
Yes, madam. But next page, my lord, 11, 12, 13, para. Para 11, para 12, para 13. In report ধরুন। দেখুন 11, 12, 13 দেখুন আপনার grievance শেষ হয়ে গেছে। Para 11, 12, 13.
Yes.
In an earlier petition, being WPA 172 of 2021, the petitioner alleged unauthorized construction made by the private respondents on PWD land. By an order passed on 5th March 2021, a coordinate bench of this court directed the concerned authority to consider and dispose of the representation made by the petitioner in this regard, after giving an opportunity of hearing to all the necessary parties within a stipulated time frame. Stop. The order not being complied with, the petitioner filed a contempt application wherein the concerned authority submitted an affidavit before the court stating that the private respondents have made unauthorized construction on PWD land. The petitioner submitted a further representation to the concerned authority. Where is your representation?
Presentation, my lord.
66?
66, my lord.
Yes. On 28th February 2023. Requesting necessary action against the illegal encroachment and unauthorized construction made by the private respondents. Right. Submitted on behalf of both the parties that during pendency of the writ petition, the representation submitted by the petitioner has been taken into consideration by the concerned authority, and notice under section 10(1) of the West Bengal Highways Act 1964 has been issued upon the alleged encroachers, including the private respondent. And in view of the above, nothing further remains to be adjudicated in the petition. Stop. However, since proceeding under section 10 of the Act of 1964 has been initiated, the concerned authority be directed to take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law. Service police, the none appears for the private respondents. Service respondents. None appears for the private respondents despite service. Next.
At number 14. Statement.
My lord, I am appealing for the petitioner in this matter.
I am appearing for the private respondent number 5 and 6.
My lord,
State, Mr.
Yes,
Congressman.
Ram, the state.
Yes.
my lord, the affidavit of service. My lord, the matter arises out of out of an unauthorized construction made by the private respondents, blocking the egress and ingress of my client, the petitioner. My lord, the encroachment has been made on public land, that is the PWD road, and accordingly, the petitioner made representations before the PWD authorities. Representations would appear on page 34 and page 37 to inquire and make appropriate proceedings so that such unauthorized occupation may be.
Demand of justice.
Yes, my lord. Yes, my lord. Demand of justice.
It is also an application under right to information.
Yes, that was there, but not on the Right of Information Act. I'm not going under that. Well, initially the construction appeared to be.
All of them are demands.
Yes, my lord.
Have not filed a representation personally.
My lord.
Demand of justice
My
cannot
lord,
be directed.
if I could not spend more time, because if I do that, the construction would be completed by the private respondents. That is the urgency, my lord. That is why, my lord.
What difference has it made? An application through the learned council and your own application?
Yes, my lord.
So why didn't you come up with a fresh application before the authority? I'll grant you liberty.
My lord.
File a fresh application within 7 days. It will be disposed of within a stipulated fee.
My lord.
Right?
Yes.
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 Private respondents will be heard when the matter is taken.
Only thing Lordship will,
Demand of justice cannot be directed to the
only thing Lordship will record that the private respondent constructed after having a sanction plan from the panchayat.
And my lord, my instruction is the panchayat has issued notice of stop work on that construction.
I have that sanction plan with me.
Yes.
I have that sanction plan.
Panchayat has issued stop work notice on that.
I'll record your submissions.
My lord.
Petitioner complains of unauthorized construction made by the private respondents on PWD land. The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the private respondents that the private respondents have made construction in the plot in question upon obtaining sanctioned plan from the panchayat. In reply, learned counsel for the petitioner submits that the panchayat has issued a stop work notice upon the private respondents in regard to the said construction. Paragraph, it is submitted on behalf of the state respondents that the fourth respondent is directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fourth, with liberty to the petitioner to submit a comprehensive representation before the fourth respondent within 7 days.
My lord.
Within 7 days from date. Stop, the fourth respondent is directed to consider and dispose of the representation within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Because proceeding needs to be drawn up.
I'm grateful, ma'am.
No, Panchayat.
At number 15.
For the state family. Yes.
Lord, I wish to appear on with the petition. Well, this is the second round of writ petition, my lord. The earlier order appears at page 38. That's all.
It's 38.
38, my lord. Third paragraph. It is submitted by the learned. Well, may I read it out? Or? It is submitted by the learned counsel appearing on behalf of the petitioner that the petitioner was granted patta in respect of the land in question as a land loser and was possessing the same by recording his name in the record of rights. The highway constructed by the state respondents runs through a portion of the petitioner's land, despite the fact that the said portion was never acquired. But I am emphasizing over there. The petitioner submitted a representation before the concerned authority in this regard, praying for compensation in respect of the utilized portion of the land on December 20, 2021, which was not been considered, my lord. Eventually, my lord had been pleased to pass an order directing the authority to consider a pass a reason order. But the reason order appears at page 43 by rejecting my prayer with the observer 43. The relevant portion at page 43 order sheet, the paragraph start with in the meantime. In the meantime, the existing official records are examined. It appears from the official record that the suit plots are not affected in any land acquisition proceeding.
I really do not follow. The state authorities do not understand what is said. Admittedly, the land has not been acquired, it has been utilized.
Yes.
So what is the meaning of this? Authority.
The requiring body.
Yes. It is disposed of by saying that it is not acquired. We all know that it is not acquired.
At present, the land was not acquired.
Yes, that is
But
admitted.
if it is the requiring body and other department is acquired, that there is no any documents or any notification. The land is acquired.
Mr. Monroe, please try to understand. Admittedly, the land was not acquired. There is no dispute about this. Despite which it was utilized by your authority. That's why the petitioner has asked for you can acquire the land and pay compensation or return the land to him. You have already stated that the land is not acquired, so he cannot get compensation.
It is true that land was utilized by the requiring body.
Who is the requiring
For
body?
the sake of argument, government party আছে কেন? Also kindly call for the executive at the requirement.
You are representing him.
Lordship.
Then call for him.
The report will submitted from the requirement. That portion of the land, utilized or not, it will be saved by the requiring body.
You are representing the requiring body also. So this report is disposal doesn't mean anything at all.
Lordship, according to the report,
Followed what was there.
according to the report, my lord, it is mentioned the honors of the payment of the compensation.
To call for Bengali reports and Bengali orders now. Your officer either doesn't follow English or doesn't follow the law at all. Yes. What do you
From the timing, my lord, the call for the report, my lord, from the
come back with the report?
from the
Please understand,
from
Mr.
the
Land has not been acquired, admittedly. You have utilized a portion of the petitioner's land. So the petitioner is asking for compensation. And you record that land is not acquired, so no compensation. Great. I really wish to call these persons personally and speak to them in court. Let him come back with the report.
No. According to the latest report of the special land acquisition officer, the honors of the payment of compensation naturally lies upon the requiring body who utilize the said land for construction of the land. So,
You
at
are
least-
representing the requiring body also? So it is your honors? So please take necessary steps in this regard. Come back with the report with a positive, concrete report, which means something.
Lordship.
Yes. The order passed by the Special Land Acquisition Officer, South 24 Parganas on 15th March 2022 is assailed in the repetition. Stop. Good. The said order demonstrates that the plots in question have not been acquired, and therefore the petitioner is not entitled to any compensation for the same. Stop. Stop. It is not in dispute that the plots in question have not been acquired. Stop. The petitioner says that a portion of the plots has been utilized by the respondents without acquisition. Stop. The petitioner has claimed compensation for the same. Paragraph. The state respondents seek to submit a report in the form of affidavit in this regard. Paragraph. Let the matter appear on the book. Please have an advance copy.
Look, the respondent number 4.
It's appear under the same heading after the petition.
As your lordship.
Lordship, respondent number
possible,
4 kindly
prior
mention.
to addition.
Respondent number 4.
Or will come back with the report. The learned counsel for the state respondents submits that the fourth respondent shall submit a report in the form of affidavit in this regard. Paragraph. Such affidavit be submitted on the adjourned date upon service of notice to the service of advance copy to the petitioner. Paragraph. Let the matter appear in the same heading. Well, come back on 18th May.
18 May. Fine.
Macho.
Ulta.
Number 16.
Not for the state respondent.
Appear for the repetition.
Not in compliance with the lordship's order. I filed the report in the form of an affidavit. I am also handing over the report, same report to my learned friend.
Okay, now.
Not he did not file it. I just told him he should have filed it. Today morning only he has given to me. I said it that you should have filed it earlier. The lordship kindly look to the order. That is R1, which has been passed and same has been communicated to him. And a joint survey was conducted by the three-man committee. And the report to that effect on mass petition also was filed, that is R2. Using the heavy machineries. Against that, there was a furor about R1, page 9. Page 9. This is the order passed. And that has been communicated to him. On 11/10, order has been passed on 29th August, and it has been communicated to him on 11th October 2022.
Yes, but you stop issuing challans from November 2022.
Not the challan, the 1 lakh demanded because of the time, and again he was using the heavy machinery. For that, there was a furor over the locality. A mass petition was filed by the locality. The joint survey committee also was, your lordship kindly look to.
Mr. Mujumdar, will you go through the report and come back?
But they have revoked the suspension. Please see not.
Yes, R1.
That's their own order.
Yes.
So what remains in not issuing challan?
Yes, because of that, your lordship kindly see the R2,
I mean, they issued challan for the month of September and October.
Page 60, R3, page 60, your lordship kindly see.
R3.
R3.
Yes.
Regarding the illegal extraction of sand over plot number such and such. Enclosed, please find here with a mass petition submitted by GHOSH and 104 another permanent inhabitants of the village Punojpur of such and such place. Your lordship kindly see. There was a mass petition and local joint inspection committee also was held. Your lordship kindly see that one. That is at page 16.
Page 16.
Page 19, my lord. Joint Survey Committee report. Page 19 R5. In the Joint Survey Committee, Deputy Magistrate and Deputy Collector Bishnipur, SDO Amrokanon and SDLLR Bishnipur field inquiry to assess the damage of embankment of the river Darakeshwar due to mining activities. Respected sir, you also can see that. The mainstream of the third paragraph, the penultimate paragraph of that letter, you also can see. Mainstream of the river Darakeshwar has been shifted to the left side from the center of the river, which is causing soil erosion and severe damage to the embankment. The agricultural lands are largely affected and damaged. Some dwelling houses, mandirs are now standing at the border of the embankment, which may be engulfed in future if further erosion continues.
Don't you think this should have been done in presence of the petitioner?
Number one. Number two, has it been stopped for all other excavators? And this is an exercise to be undertaken before the lease is granted.
Kindly see the last one.
No, this is tailor-made, clearly tailor-made.
R6, page 24. The center in charge DMS Bakura writing to the ADML LLO on verification of the latitude and longitude data number such and such. Received from SDO, it is found that the coordinate 23 latitude, that's some technical point. It is found that the sand block of Lacey, Tapos Portal is 642 meter distant from the mentioned point.
Yes.
What does this mean?
The river bank point has been shifted. So the land mining which was done by the Tapos Portal, I mean the petitioner, that is not.
Activities in that area? Yes.
That part not, I do not
Please
know.
come back with an affidavit stating so that you have stopped all the mining activities in that area.
Particular that area.
Due to shifting of river.
That I'll come back to.
Because the petitioner cannot be penalized. And
No, the penalized was done. Why the penalty was done? Because of the using of the heavy machinery.
Done it.
That did not stop.
Anywhere in your order?
No, they penalized me to buy peace. I paid 1 lakh of rupees.
Yes.
They revoked the suspension. They issued me challan for 1 month. Then again stopped.
The Lord, your Lordship, can you see that? Challan was revoked. After that, he was doing the same job. Illegal mining of diamond, using the heavy machinery. For that has been stopped. Time and again he was using that. Only that part not I have to come back with that.
Shifting of river bed, nothing else.
That part only I have to seek the instruction. If your Lordship so desires, I can come back with another affidavit. There whether the same thing has been affected to the other.
Yes.
That I will come.
They have not. I can show to your Lordship the immediately adjoining sand mine. But in the meantime, kindly permit me to lift in terms of their own circular.
I'll give you a week's time. Why don't you use an exception to this?
I tell you, Lordship, what the difficulty is. This report does not stand in my way. Number two, what the difficulty is. From June 2023, there will be stoppage of excavation for a period of 3 months due to monsoon. And not all this royalty that I had paid to the government, now I had paid a certain amount in advance. I can't lift the mine for 3 months. I have to pay my laborers. And it is also a question of my livelihood and my employees' livelihood.
Your Lordship also kindly look to the mass petition R2.
But mass petition, we all know how it is done.
The contents of the mass petitioners. Your Lordship kindly see that. আপনার নিকট আমাদের বিনীত নিবেদন নেই যে আমরা নিম্ন স্বাক্ষরকারীগণের বিনীত অনুরোধ ইন্দাস থানার কুঞ্জপুর মৌজায় দাগ নাম্বার 2272 জেল নাম্বার সাচ এমএল হোল্ডার মাইনিং লিজ হোল্ডার তাপস পোড়েল কুঞ্জপুর মৌজায় সমস্ত এলাকা এবং বামুনিয়া মৌজায় সমস্ত এলাকায় রাস্তাঘাট করিয়া বালি উত্তোলন প্রস্তুতি গ্রহণ করিতেছে ও পোগল্যান্ড মেশিন ব্যবহার করে Not Yorosically, I am emphasizing this word. Pogland machine ব্যবহার করে কুঞ্জপুর হইতে বামুনিয়া মৌজা পর্যন্ত রাস্তা তৈরি করে নদীগর্ভের পরিবেশ নষ্ট করিতেছে। ইললিগাল স্যান্ড মাইনিং এবং বাঁকুড়ার নিজস্ব মাইনিং লিস্ট চিহ্নিত রাস্তা বাদ দিয়ে হুগলির উপর দিয়ে জোরপূর্বক বালি উত্তোলন করিবার জন্য প্রস্তুতি গ্রহণ করিতেছে। এমতো অবস্থায় মহাশয়ের নিকট নিবেদন উক্ত তাপস পোড়েল যাহাতে সমস্ত এলাকা জুড়ে বালি উত্তোলন করিতে না পারে এবং মাইনিং লিজের নির্দিষ্ট সীমানার মধ্যে হয় এবং নির্দিষ্ট স্কেচ ম্যাপের মধ্যে বালি উত্তোলন করে তার জন্য আবেদন করেছে অতএব মহাশয়
Yes, please direct them to supervise this.
Not that you also kindly see the order at page 12 which has been passed by the district land and officer. and which same has been communicated to the petitioner.
But this has all resulted in a fine being imposed and suspension order being revoked. But why is my learned friend
This is the first
going
cause of
back
action,
to?
I hope not the order in terms of your lordship's order, which has been passed by the.
12 order is over already.
Not
It
your
has been
lordship.
revoked.
Your lordship kindly appreciate the order which has been annexed to this report passed by the district land and land reform officer, which starts from page 9 to page 12.
Page 12 is that it has been revoked. So that part is over.
So it is a not.
And it's a September order.
No,
Yes,
no,
you have talked about your issued challans.
It-
You have stopped from November. What is the justification? What is the reason?
That's the revocation order.
This is annexed to the.
Yes, not I. Annex.
R1, I think.
R1. That is on 10, 11:10.
After.
Yes, this is annexed, page 7.
Sir, issued 2 challans for 2 months.
Yes.
What is the reason for stopping after that?
That part not, it has not been stated in the affidavit. I do find it.
Suppression of facts. Suppression of fact.
No, let me,
And the marks petition also says that he may be allowed to.
your lordship, can you allow me to come back with the further affidavit? Will your lordship will kindly allow me to come back with the further affidavit and stating this, all these reasons?
Let them take their own, but not in the meantime, kindly direct them to permit me to lift in the terms of their own. Page 52. Please have a look at page 52.
Your lordship give me short period. Not
in this way, they cannot ward me off like this.
My learned friend will bear with me, Lord, only a short period, your lordship.
But they cannot set up defenses like this.
Because the mass petition also says that he may continue with his mining within the specified plot. He can do that. He can strictly adhere to what you've given him.
And I have an environment clearance. Whereafter I only got this lease. Page 52. But this is the due excavated, due amount of excavation. But I am way behind the capacity permitted.
Does not say so. Mass petition.
Why should mass petition be relied upon by the state?
It is local people agitation. That has to be also taken into consideration, the one the local people say so.
I'm referring to the mass petition itself.
Mass
What
petition.
does the last paragraph say?
Yes, অতএব মহাসড়ক পরিচিত ঘটনাটি বিবেচনা করে যাতে তাবৎ ফ্লোরের বালি উত্তোলন বন্ধ করা হয় তাহার সুব্যবস্থা করিয়া বাধিত করে। Last paragraph, page 13. অতএব মহাশয় উপরিক্ত ঘটনাটি বিবেচনা করিয়া যাহাতে তাপস পোড়েলের বালি উত্তোলন বন্ধ করা হয় তার সুব্যবস্থা করিয়া বাধিত করে।
Only
last paragraph.
only this person. এবং এর নির্দিষ্ট সীমার মধ্যে হয়। এবং নির্দিষ্ট স্কেচ ম্যাপের মধ্যে বালি উত্তোলন করে তাহার জন্য আবেদন করিতেছি।
এমত অবস্থায় মহাশয়ের নিকট বিনীত নিবেদন please see that paragraph. The last 3 lines of the earlier paragraph.
I am ready. I am ready. Let me come back.
He confines himself to the area granted to him, allotted to him. What's the difficulty?
Your lordship, can you allow me very short, limited period of time? I'll come back with another affidavit and stating everything.
Fine.
Monday, not very short. Blood,
You
I
see,
think
the
blood,
petition-
blood, next to it, next.
Wednesday, very well. But with all the details, otherwise an order will be passed.
My lord. লোক পরে জানাই না যাচ্ছাত করে দিল
Report.
এক্সেপশন কিছু দেবে না যা বললো বলে দিচ্ছে
In the form of affidavit submitted on behalf of the respondents.
দেখে
Taken on record.
আমার কাছে নিয়ে আসে না
Learned counsel for the respondents seeks to submit a further report in this regard. Paragraph, let the matter appear at the same heading on.
the report what happened, should I take it back or your lordship will give it?
Third page next Wednesday.
Pardon me. The report will, shall I take it back or?
No, this is part of record. This is part of record.
Pardon me.
Please clarify these issues.
Yeah, yes, sir.
Number 17.
Strategy on behalf of general development.
Please, your lordship, Lord. Lord,
Sir,
yes, there's one defect which I need to, my lord, remove. Below the representation which I have made, below has to be routed through below the Department of Industry and Commerce. Below they have not been made a party in this writ petition. So kindly allows me, below, to add them and to serve upon them as well. Below, my respectful submission here is, below, I will not pray for, below, an order for directing them to consider. My lord, I would, my lord, pray before your lordship, my lord, if I'm entitled to it, my lord, kindly grants it. Otherwise, kindly do not send it back to them because it's become a little bit of a useless practice now, my lord. My lord, if I'm entitled to force major, my lord grants it. My lord, if I'm not, my lord rejects it from here itself. Because I'm putting them on notice, my lord, that I will be marked.
It's their decision.
They have not taken, they will not take any decision. They will not take any decision. My lord, I have seen, my lord, representations being,
In fact.
yes, if it, absolutely not. If it's a policy decision, court will not impose. But if the law allows me, my lord, an extension, the court, my lord, would be very well, my lord, within its limits to allow that.
What is being spoken about the definition of force majeure?
Yes, my lord, I say, my lord, force major cannot be contractual. Force major, my lord, can well be contractual at one aspect and well be, my lord, beyond, my lord, because I don't think in 2017 they could have understood, my lord, what COVID was. But once the government of India says that it's a force major, my lord, then that, my lord, has to be, that benefit has to be given to me.
Has the government of India said that?
Yes, my lord, it has. It has.
There is no-
There is a notification. There is a notification.
Can we help the court with that?
Certainly, my lord. Definitely. Then that's why I say, my lord, I will bring all that before your lordship, even by way of a supplementary affidavit. So they can't say that it's a contractual force major. Yes, 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 definitely, definitely. Certainly, ma'am. Certainly.
Let him come back. On prayer of the petitioner, liberty is granted to complete whom the
Well, the Secretary, Department of Commerce and Industries.
Secretary in the Department of
Industry, Commerce, Enterprise. Enterprise.
Department of Industries, Commerce and Enterprises, that was given
Address? No, we'll give it.
at address and email.
Address is 4 Abanindranath Tagore Sorori.
Galaxy বললি তো হয়।
ওটা এখন নাম হয়ে গেছে অবনীন্দ্রনাথ টেগোর সরণি।
Now it's all.
Where we go from Uttam Kumar to Mila Suchitra Sen, we don't even know where we are.
The name of the road of my house. Different name altogether.
Altogether. Very difficult. Very.
Calcutta?
16.
16. 700016. 16. Huh? 700016. As respondent number 5 in the petition. Paragraph, the cost title of the petition be amended accordingly.
Ah.
You want to use a supplementary? affidavit?
Yes, my lord. I'll put all those documents
The
together.
petitioner paragraph, the petitioner seeks to use a supplementary affidavit annexing relevant documents. It seeks now for on prayer of the liberty is granted on prayer of the petitioner. Further liberty is granted to use a supplementary annexing relevant documents. Will you come back after vacation?
7 days, my lord. I'm out of work.
Let the matter appear on the same heading on 16th May.
It every day, my lord, deteriorates, then again stabilizes. No, my lord. It's been 3 months now. Grateful to Lordship, my lord, for inquiry.
No,
not this. But 18. I am for the state, my lord, allocate Neelam Singh.
Your Lordship, in this matter, Mr. Devashish Dash is appearing on behalf of the petitioner. He is currently engaged in court number 13.
My lord,
I'm praying for only not this, not today,
Devnath
Your
Mahato
Lordship.
appearing for the private respondent number 13, my lord, praying for not this week, my lord, next week, any day, my lord.
You come back after vacation.
Yes, my lord. It's after upgradation.
Yes.
This matter has been upgraded.
Petitioner
At the instance of the petitioner.
Your Lordship, I'm not his junior. His clerk only requested me.
That is my embarrassment.
As well, your lordship.
On prayer of the petitioner and the private respondent also.
Yes,
On
13.
prayer of the petitioner and the private respondent, the matter is adjourned. Let the matter appear under the same heading on 8th May.
Gratefully, Your Lordship.
Sorry? Grateful, my lord.
8th May, because
My
it's
lord,
an
my
upgraded
my lord, my lord, my lord. 8 May. Much. Devnath.
Item number 19.
Item number 19, my lord, I appear for the petitioner.
Yes, sir.
My lord, my lord.
My lord, I am appearing here for DFCCIL behalf of Rini Bhattacharya. We are first time appearing for this matter, so kindly take some days, adjourn for some days because
I appear for the BFCC.
Rini Bhattacharya.
No, my court
Why
number
you
is
have the necessary instructions?
well,
No.
BFCC, my lord, I do not understand the application, my lord.
We need some instruction, need to take some instruction.
You're appearing for the railways.
Yes.
Lord, the answering respondent, my lord, the additional district magistrate, my lord, who is the, my lord, competent authority. Yes, my lord, I have served, my lord. This is the affidavit of service, my lord. My lord,
It's asking for some time, so let her come.
then, my lord, a very short date may be given. My lord,
A very
this is
short
another
date after
communication, my lord. My lord.
A very short date after the petition. Let her come. Please take instructions in the meantime.
My lord, kindly take this also on record, my lord. This is the, my lord, this is the subsequent communication to the ADM, my lord.
So supplementary affidavit.
Supplementary affidavit service.
Grant you
That is
liberty?
supplementary service.
I'll grant you liberty to use a supplementary affidavit.
Supplementary affidavit of service, man.
Yes, yes. Affidavit of service. None appears for the state respondents despite service. Paragraph on prayer of the petitioner liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph on prayer of the railway authority, the matter is adjourned with the on 8th June.
My lord, only one thing, my lord, supplementary affidavit of service, my lord. This is only a mere communication service, my lord. My lord, this is the affidavit of service. My lord, we'll see in the last page of the annexure. Fine.
Come back with the service. On prayer of the probably 8th June. 8th June. Immediately. Next.
And number 20.
My lord, in this matter, Mr. SUVRA is appearing for the petitioner. Right now, my lord, he is in code number 550. I am praying for adjournment on his behalf.
But we beg to appear on behalf of the private respondent number 11. It's upgraded, my lord, by mentioning twice. It was upgraded matter, my lord.
Yeah. That is engaged in a hearing, my lord.
After vacation, on prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 13th June.
Grateful, my lord.
Amta diye debe. Amta. The big appear for the state respondent. Number 21.
Service.
21.
Yes, my lord.
State.
In national highways.
My lord, this is the order, my lord, which is passed on the earlier occasion because the arbitrator has not made party. Subsequently, your lordship was granted leave to add the Commissioner Midnapur division as a party to this proceedings and directed to consider the representation which was earlier represented. Same, my lord, page P14, my lord will find. Because the arbitrator was not made party, because I have submitted before
Yes.
that whether the arbitrator can be made party or not. Your lordship's direction was that observation was that unless there is a direction upon that person, you cannot give the time frame for the purpose because he is the adjudicating authority. So that that's why, my lord. So similar order I am praying before your lordship, my lord. P14, my lord, is the representation which is there, not representation, but application. Yes, application P14. Page, my lord. Page 14, my lord. P এটা কি কত? দেখো তো 14. Last two pages. কত?
সেই ইনস্ট্রাকশন নিতে আমরা করবো না।
এটা কত?
Page mark is the last three
No, no,
pages, my lord. There is no.
Running 24, my lord. No. P4.
Application for assigned for referral.
Now it was forwarded to the arbitrator. My lord will find it. There is a
party here also?
No, that's why, my lord, the same prayer, my lord, I'm praying that it is forwarded for the purpose of.
Yes, let this be allowed, considered.
My lord, may I come back with the instructions?
Hmm.
Because
Not as
my lord, the under
merits.
my lord, the lordship kindly see that understand therefore request before your good sir to be kind enough to refer the said LA case for remeasurement, reassessment, re-evaluation, lordship under the provisions.
PG for application.
That is the only thing, yeah.
Well, that's
Same application, everything possible.
You have blanket instructions for all this.
আর কিছু আছে দাদা বলো?
Only
কিছু আছে?
না, সৌগতর কেসে আমি না ইনস্ট্রাকশন নিয়ে করতে পারবো না, অন্য অন্য বলে দিতে হবে। ইনস্ট্রাকশন দেওয়া দরকার না, ওর কেসটা ঠিক মানে সোজা পথে হাঁটে না। অন্য কেস হলে বলে দিতে হবে, কিন্তু ওর কেস আমি করতে গেলে
my lord, have the
The petition will be disposed of within only a direction for disposal of the application. Nothing on merits.
if it is not already done, ma'am.
my lord, that is the issue, my lord. Without
I am recording.
I have got the inspection, my lord. That is my inspection.
In this matter? In this matter, sir?
my lord, it is a total, my lord, total.
6 matters are there, 21 to 26.
23.
Yes, 21 to 26, same.
Has it been disposed of, Mr. Dey?
Yes.
Mr. Dey, has it been disposed of? That
But only one thing, my lord. They filing an application, my lord. That is technical. They can file an application before the authority. That is arbitrated.
আরবিট্রেশন হবে, রেফারেন্স হবে না।
the application is under 3G files.
Yes, my lord, but that is if your lordship will say 32 months. That is if your lordship will say 26 months. If you take the other.
In 23.
23.
In fact,
26. I don't know, 26.
because if it had been on merits, I would have allowed it to make
We don't
instructions.
even know whether the arbitration proceeding has already been done or not. my
No,
lord. That-
from the report it appears it cannot be done, otherwise my lord, by spending it.
Instructions, my lord.
Reach.
Application of the appointment.
হবে সেটা দাও। একটা ফাইলে
But it is to the arbitrator.
Yes.
Address to the arbitrator.
Address to the arbitrator, but through the and.
Through the property, the office, my lord, what happened, there is a. It depends.
Mr. Dey, technical. Let there be a direction upon the arbitration.
Previously, my lord, they filed an application for reference of 80. According to them, my lord, the reference is.
No, but this is a 3G file
Yes, ma'am.
application, so no evidence is required.
My case, very disclosed.
All cases will be disposed.
already they have made an application before the arbitrator,
Yes,
but that has not been, it appears from the matter of the representation. that আমি একটু পড়ে নিই।
Yes, I have submitted, divisional commission is the arbitrator.
Is the undersigned has already made an application for initiating a reference under section 3G5 of the National Highways Act, and the same has not been referred. If it is not referred, well, let it be referred before the arbitration.
So I will learn it arbitrage. Nothing, I'll record that I'm not going into merits.
My
No,
But I don't even know whether the lord's arbitration procedure is already.
no, that is not over from their report. From their report it appears. It is not over.
Sure.
Subject to correction, my lord.
Do not say anything against this, yes.
I'm not saying anything against of it. But there is no provision like section 80.
That
of
reference, that is technical.
ছেড়ে দাও, ছেড়ে দাও, যখন
Section
চাইছেন না, ছেড়ে দাও, চাইছেন না।
They have referred to a word reference, but it's a 3G file application.
Fine.
Will the arbitrator speak with it?
If
And
it
this
is not
will
referred
not
before the arbitrator, let it be referred.
Yes.
Should have well, come up
If it is
to
already
this
done.
court that I have filed this application before the arbitrator, kindly.
That the application is before the arbitrator, if you file, if you see.
Yes.
They have recorded some unwarranted.
My lord, there are some technical difficulties.
Third learned councils, affidavit of service and all the.
Oh, in all the matters. 21 to 26.
Councils for the parties. Paragraph on prayer of the petitioner, leave is granted to add to implead the commissioner, Post-Chief Medinipur division.
Same.
Division, comma, Keranitola. This is also same.
Same.
Keranitola, comma, Hospital Road, comma, Post Office, Post-Chief Medinipur, District, Post-Chief Medinipur, comma, learned arbitrator as respondent number
9, my lord. 9.
9 in the petition. Paragraph, the cost title of. Paragraph.
Kindly add in accordance with.
Absolutely. Cannot be illegally done.
The court will direct something to do illegally, my lord, contrary to the statute.
The time period they have lost.
It's like giving a direction not to murder. someone.
Time period, my lord,
Time period perhaps lost.
perhaps lost. What is the, I do not know, my lord, let my learned friend can enlighten me on the ground that what is the statutory arbitration, what is the time period for filing of the application? That is a,
You still continue with the submissions or may I dictate?
I will.
The petitioner is agreed by the compensation granted to for
okay, but
acquisition
leave
of
till to
by the respondents and has submitted an application under section 5 of the National Highways Act 1956 before the learned arbitrator on 9 December 2022. Stop. The said application is yet to be considered. Stop. The petitioner pays for a direction from the concerned authority. Consider the application at the submitted on behalf of the respondent. Ninth respondent be directed to consider and dispose of the application in accordance with law. Paragraph in view of the above, so directing the ninth respondent to consider and dispose of the application filed by the petitioners dated 9 December 2022 within a period of 2 months from the date of communication of this order, upon giving reasonable opportunity of hearing to all the interested persons, including the petitioner, comma, in accordance with law. Paragraph, it is needless to mention that the decision taken by the concerned authority shall be communicated to the petitioner within a week thereof. Paragraph, it is made clear that this court has not gone into the merits of the case and the concerned authority shall be at liberty to deal with the application of the application filed by the petitioner independently in accordance with law. Paragraph disposed of objection.
Now, the arbitral proceeding has not been concluded or not.
The report says it was not been.
That has been mentioned in this order.
The report says.
Because I don't have any copy of this, madam. Well, the liberty,
One by one.
well, we have big banner.
well, the liberty has been given to add as a part of it.
Yes,
Yes. That's one number 9.
yes.
Thank you.
Next.
Item 25, I am applying for the statement.
I'll call one.
আরে আপনার ম্যাটার চলছে
Yes.
ঠিক আছে
Item 22, you're
Item
appealing?
22.
I would check, I would like to see the date of the investigation. It's the same.
সেম এটা জজকে বলুন না
সিমিলার ম্যাটার
না ডেটটা রিপ্রেজেন্টেশনের
নিয়ে চলে গেছে কি
কোনটা তোমার
22
2247
মানে the same date madam
same day.
Respondent number 9 here also?
yes madam
No, Manor, there is no respondent number 9.
no they should as a part
add as well
Yes, yes.
Giving liberty. The presentation is. 9 December.
page 20 Ashok Kumar
My instruction may be kept with the report.
Instructions submitted on behalf of the state.
page 23 Ashok Kumar
Instructions submitted on behalf of the state.
জজকে বলে দেখো
23
Yes.
অশোক কুমার পাত্র
এটা এই ফাইলে যাবে।
23.
My lord, I am for the state, I have filed that.
Report submitted on behalf of the state respondents is taken in report.
Date is same, my lord.
Respondent number 9 will be. Same.
গীতা রানী পুতি
Statement of facts.
No, 9 to add to it.
same date.
State. 26, no one. Mr. Shubhobroto Dotto and Shonatan Paja, who are they?
Sanatan Banja is there.
26, my lord. He will not 25, my lord.
26, I'm calling. 26 and.
Same date, my
Same
lord.
order.
Same.
But he is in 26 only instead of 25.
I think
25 is appearing.
Boroma.
25.
কোনটা? না, এটা দিলাম।
25%.
25 বললাম তো। অসিত পাত্র নাকি?
Where is the evidence of service? In 25.
File mine. Have you been?
Of service, please.
দেখি 25 টা বলো কি নাম আছে দেখি দাদা একটু দেখি লিস্টটা দাও কি নাম আছে দেখি বাড়ির মডার্ন মান
Yes. 25 এর বলুন এটা 25 is the valid service non existent
চলে যাও
specified service.
আমরা হ্যাঁ সেই আপনি 25
Same address.
Yes, ma'am.
নামটা কি?
23rd টা নাম লিখতে নেই। একটা কপি দিয়ে দিও কত বলো।
হ্যাঁ হ্যাঁ
25 থেকে 23
বাড়ির পরনটা আমি 25
পাইলট আবার এই একবার হচ্ছে 25 ওখানে লেখা আছে 26
পাইলট মিস্টেক মাইলিং মাইলট আইটেম 25 বাড়ির পরন I think Mohanty my lord, I am appearing for the state my lord. This is I am holding the brief my lord.
Once you say 25, once you say 26.
Disgusting.
My class
26 you're not there.
no my lord.
Rajiv, 26 is service regularized. 25 only.
It's sure.
26 I'm ready.
Yes, ma'am. ঠিক আছে চল হয়ে গেছে
হয়েছে?
even I for the state
ভুল ভাল করে ক্লাস মিস্টেক
দাদা এটা নেবেন
লিভ দিছে
Yes, Mr. Bhatt.
Yes, this is my affidavit of service, my lord.
This state. Please.
Only state, yes. I appear for the KMD in this matter. The my lord, if you also kindly turn to the page. My lord, my lord, this is pursuant to your leave granted by your lordship. Earlier I moved this, then my lord, there was a defect. So I sought for leave from your lordship, my lord. Your lordship granted me leave. So accordingly, I am filing this writ petition. And the order is at page 13 of your lordship, page 12 of your lordship's order, my lord. Yes. Lordship, can you turn to page 14? My lord, this is the notification under section 4. My lord, your lordship will find I'm concerned with plot number, my lord. This is CS plot number 61. No, Act 1. Act 1, Act 1, Act 1. My lord, this is at my plot. I am concerned with 615. That is CS plot number, my lord. 615. Your lordship will find first, second, third, fourth row of the schedule of the land.
615.
615. Now, in the middle, your lordship find that this is a notification is made under the provisions of section 4 of Act 1 of 1894. Then lordship kindly turn to page 16. At the top, my lord, there is a Moja BG. This is a notification under section 6. Lordship kindly turn to, my lord, the schedule of the plot. Your lordship will find at the extreme left of the fourth row, 710. This is corresponding to 710 is corresponding to 615 of CS. This is RS. Now, my lord, your lordship will find the entire plot was acquired. Then, my lord, what happened? If your lordship kindly turn to my paragraph. Seven. That award is good. The award in question was declared. The total area of plot number 710 is, my lord, is 0.76 acre. Out of which, my lord, in respect of 0.32 acre award was declared. Leaving aside, my lord, the 44 acres, 0.44 acres, no award was declared. Now, your lordship knows that in the year 1984, 24th September 1984, Section 11 capital A was inserted in the Act 1 of 1894. Whereunder, my lord, this was stipulated that award is to be declared within 2 years from the publication of Section 6 notification.
Yes.
So award ought to have been declared within September 1986. May I hand over the pen? And have a look at the Section 11 capital A.
Yes.
The collector shall make an award under Section 11 within a period of 2 years from the date of the publication of the declaration. And if no award is made within that period, the entire proceeding for the acquisition of the land shall lapse. So in respect of 0.44, entire proceedings lapsed. Now, my lord, if you lordship kindly turn to Section 11 once.
Award was declared in 76. December
77. But if you lordship kindly turn to Section 11 once.
And what is the Section 6 date?
Section 6 is, my lord, that 17th January 1969. So from 84 to 86, my lord, 2 years. So, my lord, award was not made. But it's an admitted position. Now, my lord, if you lordship kindly turn to Section 11 once. Whenever any land shall have been so declared or to be needed for a public purpose or for a company, the appropriate government or some officer authorized by the appropriate government in this sorry. On the day so fixed on or on any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to the notice, to a notice given under Section 9 or to the measurement made under Section 8 and into the value of the land at the date of publication notification under Section 4 and into the respective interest for the persons claiming to the compensation. I am skipping over the, I am not concerned on this. Next, and shall make an award under his hand of the true area of the land. So kindly pause for a moment over here, my lord. 0.33 acre land award has been declared. Rest award that has not been declared. Now this is a duty casted upon the collector, my lord, to demarcate the land under Section 8. That is my PR before, because I have subsequently purchased that particular area, my lord. So, my lord, if you also can turn to Section 8. The collector shall thereupon cause the land unless and be marked out under section 4 to be marked out. He shall cause to the is to be measured, and if no plan has been made, then a plan is to be made on the same. So that is my prayer before your lordship, my lord, to demarcate the unacquired the portion which has not been acquired.
Yes.
I'm for the case. My lord, here admittedly at paragraph 7 that award was passed. It is admitted by the petitioner that entire land was acquired. That is 0.76 acres. And in the year 1976, award was passed in respect of 0.32 acres. That shows that the petitioners were very much aware of the acquisition proceeding. Since even if it is accepted that in respect of 0.44 acres, award was not passed. Since 1976, there has been no representation. All on a sudden, in 2022, this writ petition was filed, the earlier one, and withdrawing this writ petition has been filed. So the delay, whether at this belated stage, the petitioner will be entitled to raise this. So far, it is an admitted, so far 0.32 acres, the petitioner admits that the award was passed. And he claims at paragraph 9, this is the case made out at paragraph 9, that in respect of 0.44 acres, since no award was passed within 2 years, as stipulated in 11A, the acquisition stood lapse in respect of 0.44 acres. So he wants demarcation. Whether, so this part, of course, the state is to come with the relevant records, because state has to file a report stating whether award was and when that was passed. But my humble submission is, Miller, whether the petitioner can at this belated stage can raise this. I must take the point of delay. Even if it is not declared, at this belated stage, the petitioner cannot be allowed to. Let the state come with the report, we shall also. I take this maintainability point. I should kindly record it, and I shall try to substantiate my submission. 76 to 2022. Even if the petitioner had that right, that has been acquiesced, waived. Not a single representation since 76 to 2022.
Yes, state.
But I take time for filing the
Filing a report.
No,
Or how do you explain the delay?
before that, so far my little knowledge course, maintainability is something different, and delay is pertaining to the merit. Delay is your lordship has no jurisdiction. Delay is my claim is barred by the statute. Then question of maintainability, the writ petition arise. Delay pertaining to the merit, not in respect of the maintainability. Now, my lord, lordship can see. My lord, what I have prayed over here, I have prayed the portion which has not been acquired, that is to be demarcated. I don't find that this is not a claim of money, that I am asking for any money, 3 years limitation. Only thing I am praying that I am not asking the thing which is lying with you.
You were aware of this right from the beginning.
Yes,
Right
that
from the
I am aware. It doesn't mean that I might be deprived from my property, enjoyment of my property. I am enjoying my property, but for the want of development, because I tell you, the moment I will go for the plan sanctioning, they will say that what is the demarcation. That is the reason. Only for that purpose only. Well, I don't know, my lord, I putting it to myself, why delay comes into the play. Because I am not something else from you that you do this. Because your duty casted upon to demarcate your portion. You demarcate your acquired portion, not my portion. This is duty casted upon, it's a statutory application. It's a continuing breach. And maintainability is something different.
Which one is this? His. Petitioner admits the entire land was acquired. Section 4 issued, section 6 issued. What is his contention? Since award was not passed in respect of a portion of the acquired land, that portion should lapse.
Yes.
So lapsing, the claim of lapsing, when raised,
The state has to respond to this.
when raised, I am raising this. Certainly this goes to, this touches
But it
the
doesn't mean that my writ petition is not maintainable.
maintainability. Of course, whether you can maintain this petition,
It's on
that
the merit.
question comes.
Maintainability is something different under the law.
On the ground of delay,
Yes.
if the petitioner is not maintainable, then it touches the maintainability, question of maintainability.
Affidavit of service. It is submitted on behalf of the petitioners. The petitioners claim to be joint owners in respect of the plots in question and submit that though the entire plot number 710
CS, 710.
No,
CS.
710 is RS, yes.
You mean the
has plot number 710.
RS.
Measuring an area of about 0.76 acres was
Oh, sorry, RS. 615. CS.
notified to be acquired under section 4 as well as section 6 of the Land Acquisition Act 1894, award was declared only in respect of an area of about 0.32 acres. Area of about 0.32 acres on 24th December 1976. And the remaining 0.44 acres were left out, stopped. Since no award was declared in respect of the remaining portion of the land within the statutory period of time as envisaged under section 11 capital A of the Act of 1894, the acquisition in respect of the said portion of the land lapsed, stopped. The petitioners have prayed for a direction upon the state respondents to demarcate the acquired portion of the land in terms of section 8 of the Act of 1894. Well, Learned Counsel for the KMDU has challenged the maintainability of the petition on the ground of delay. Paragraph Learned Counsel for the state respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading. Will you come back after vacation? On 14th June.
14th.
Kindly, there will be a record, my lord, advance copy may be served upon. Please.
Report in the form of affidavit be submitted on the adjourned date upon service of advance copy to the petitioner.
Obliged.
Much.
Well, 28. My lord, in this matter, I am appearing on behalf of the petitioner, my lord. The fact is that the petitioner,
The respondents.
Appearing from the respondent number 1.
my lord, may I file the affidavit of service, my lord?
But in this matter, I am appealing for equal authorities, my lord. But the copy has been served to me on mail, my lord, just yesterday, my lord. But I have not
Appearing for?
Eastern Coalfield Limited, my lord. But I'll pray before your lordship, my lord, to just direct them to give me a hard copy, my lord. I shall get prepared and I'll come back, my lord. And my lord, another thing, my lord, in the order, my lord, I find, my lord, one tender, my lord, in which they are asking for stay, my lord. That is, my lord, has been challenged before Honorable Justice Musui Bhattacharya, my lord. That is pending.
The same issue.
Yes, please. One of the
My
tender.
lord, that is not known to us, my lord, because what happened,
Take instructions and come.
I will check, my lord.
Challenge the same tender before two.
What
And
happened,
my- this is
No, my lord, that is
purely a
that is
tender
on
matter, my
different.
lord. It's, I don't know how, what of your lordship has the jurisdiction, my lord, but it's a purely a tender matter, residuary matter.
No, my lord, it's a regarding land, my lord.
Lord, what happened, I tell you, Lordship, Lord, I am selected as the L1 bidder with regard to this tender. This is the tender of 9,000 crore. Now, what they have done is,
To ascertain whether the court has determination.
yes, that is why I am informing you, Lordship. Now,
Let's see
yes,
the prayer.
yes. Now, prayer E perhaps is with regard to that tender, my lord, where I am the L1 and the matter is pending before Justice Bhattacharya.
No, no,
Yeah,
my lord,
I am here to
what
inform you.
happened is that, my lord, my tender is still subsisting, my lord, without terminating me. How a similar kind of tender we passed to a third party?
Cannot deal with. tenders
Exactly, exactly, my lord. Exactly,
A different bench has been designated.
absolutely.
This cannot be called a land matter, it's a tender matter.
Even today, the matter is in the list as item number 16 today. Their arguments are complete now. I think, not something is behind this, matter, not so that could be stalled, perhaps. The prayers are like that.
I'll release them.
I am obliged, my lord.
We want a hard copy.
I will serve. I will serve.
Submitted on
I'll serve.
respondents. That the matter relates to a tender process. And is pending before a coordinate bench. Paragraph in view of this. Matter is- Lack of determination.
My lord, in the said matter, we are not made party. We are to.
Approach the court.
I will approach, my lord. I will approach by this writ petition, my lord. By this writ petition, I will approach, my lord.
You can ask for being added as a party in that litigation.
But hard together, hard this matter, analogous hearing be given.
Anything.
Analogous. That is the main thing, because we have some different prayers.
Next.
I am obliged, my lord.
Number 29.
Yes, affidavit of service, have you thought?
My lord, I am appearing for the state, my lord.
Yes.
My lord, what happens, my lord? My lord, I had a long-term mining lease. My lord, what happens, my lord? The position was handed over to me, my lord. Come to page. I'm state-wise coming to my lord. Page 12. On 16th June 1916, the position was handed over. Page 12, annexure P1.
Yes.
Then, my lord, all on a sudden, on 24th August 2016, the additional district magistrate and district land and land reforms officer, my lord, come to page 16. This is the continuation. Page 16, my lord, come. What happened? Close down of all mining lease, these of the district of Bankura, such and such, National Guild Tribunal and West Bengal too. In compliance with the order dated 27
February 2012, the Honorable Supreme Court of India in the special leave such and such order dated the Honorable Green Tribunal, you are hereby directed to stop extraction of sand in the river bed in connection with the long-term mining lease after receiving the instant order. My lord, what happens, my lord? At that time, on the basis of the Supreme Court order, Supreme Court directed in the case of Deepak Kumar that a mining lease should have to be given for 5 years. I have been given 2 years. And environment clearance is essential for obtaining the mining lease. My lord, what the additional district magistrate has done, on the basis of the Supreme Court order, he have directed a piecemeal, given me on the basis of 2 years. But the recommendation I will produce before your lordship the judgment, and the entire matter until and unless I obtain the environment clearance certificate, I can't start the business. My lord, next page, my lord, P3, page 17.
Yes.
I have submitted the feasibility report of form in 1 and all. I have compliance in respect of the environment clearance certificate. My lord, the environment clearance certificate up till now has not been given to me. My lord, I am coming to my lord, last representation, that page 19. What they are doing by the e-auction on the 29th July 2016 has been come into the force. My lord, they are entertaining the e-auction, keeping pending my environment clearance certificate. My lord, I am presenting, my lord, I am handing over to your lordship. First, they have referred the judgment of the Supreme Court. My lord, come to page 23 first. They have referred the minimum size. Following are the key recommendations reiterated in the letter. Minimum size of the mining lease should be 5 hectares. Minimum period of mining lease should be 5 years. But I have been given 2 years. And my lord, last page 27, they have observed that until and unless the environment clearance obtained, you can't start the business. My lord, they have already stopped on the basis of the order of the Supreme Court. Mining lease, the granting of mining lease and everything. The possession was handed over, but I cannot start the business. My humble prayer before your lordship, on the basis of Deepak Kumar case, let they be considered for 5 years, and also let my environment clearance should be issued. They have kept pending still now. My lord, page 23 and page 23.
Your lease was granted prior to this judgment, isn't it?
Prior to the judgment, my lord. But they when they stop, my lord, come to page. Can you see?
Judgment has prospective effect.
Yes, my lord. The judgment was passed on 12 March 12. Now, my lord, for a moment, come to page 60. They have referred. They have stopped my business. Page 16 of the writ petition, my lord, come. Close down of all mining lease of Bakura on the basis of the judgment of Supreme Court.
As well as the entity judge, the national.
Whatever it may, my lord, the Deepak Kumar case, as the Supreme Court, there are several states, 18 or 17 state has moved, and one combined judgment has been passed in the case of Deepak Kumar. My lord, the Deepak Kumar case, the observation of the Honorable Supreme Court is that Lease will be granted for 5 years minimum. And environment clearance is essential. How the district magistrate make a piecemeal on the basis of the Supreme Court judgment? How? Whether he has got any right to make him piecemeal in respect of the judgment of the Honorable Supreme Court?
When was this judgment passed? The date of the judgment?
Judgment of my land of 2009. Judgment of the my land. Once for a moment. my
What
lord.
filed the date actually?
Date has not been put. My lord, however, my lord,
Oh, the order was in 2012. 27th February to 2012, page 16.
yes.
And when was your lease granted?
Leave was granted 216. I have already stated in my petition, lease was granted in 2016
It is after the order, after the judgment.
after the judgment. Now my humble prayer is, my lord, let the lease, my lord, if your lordships direct me to make a fresh representation on the basis of the Deepak Kumar case, they'll kindly extend my lease for 5 years and issue the environment clearance certificate. The environment clearance, I have complied all the formalities, but it is kept pending still now. This is my humble submission, my lord. On the basis of Supreme Court judgment, Deepak Kumar case. Previous in one matter, my lord, your lordships already granted. Leave me on the basis of the Deepak Kumar case.
Let us hear the.
Of course, my lord. This state is here, my lord.
Yes.
My lord, I'll take full instruction, but the close down was made in terms of the order passed by the learned NGT. That was passed on 9th of August 2016, after the lease was granted. And thereafter, the new rules of 2016 was introduced, by which these short-term lease all are curtailed of 2 years.
All are curtailed.
By the 2-year short-term lease on the basis of new rules, your lordship is aware of 2016 mine and minerals rules. These which were granted earlier prior to the judgment.
It's not a short
curtailed.
lease, it's a long-term
Yes,
lease.
My lord, it's a 2 years
It's
lease.
not a short-term license.
My lord, it is a 2 years. It's not 5 years earlier.
But
It's a short term, my lord, 2 years.
Committed according to the petitioner. You have granted a long-term mining
That is
for 2 years, which is not permissible in law.
Yeah, give you all this.
not permissible.
You have done that. You have not annexed your deed of lease.
No, my lord, I have not
My lord?
annexed. Well, I have already stated in court that the mining lease and the position has handed over. Until and unless it is registered, my lord,
Position will not be handled.
the
My
position
lord,
cannot be handled.
when position was handed over, EC clearance was not mandatory provision. Subsequently,
My lord, come to page.
mandatory.
Has
Now, he had applied before the district
clearance.
magistrate for EC clearance. My lord, not EC clearance, he had applied before the district magistrate, but I find the district magistrate is not the competent authority to grant EC environment clearance. The environment clearance officer in districts are the different officer, who is not a party here also. Well, better I'll take complete instruction in the matter. I'll come back with the complete instruction.
Let him come back with
How
the
to
report.
resolve this issue, my lord.
Please come back with the report.
My
My
lord.
lord, very short date, my lord. It is pending since 2017. It was in the old one in list and your lordship.
My lord, kindly direct, my lord, lordship would be pleased to direct respondent number 2 or 3 to furnish a report. So it will be better.
Respondent number 2, 3 report pass korte hobe.
2 or 3.
Joint secretary or assistant secretary? Who will furnish the report?
Joint secretary, better joint secretary.
The petitioner seeks a direction upon the concerned authority to extend the period of lease to 5 years in accordance with the direction of the Honorable Supreme Court, in the authority in Deepak Kumar, etc., DEEPAK, no? Deepak Kumar, etc., versus State of Haryana and others, etc., in IA numbers, intellectual applications numbers, 12-13 of 2011, in special leave petition within bracket C, number 19628 19629 of 2009. The petitioner further prays for a direction upon the authority to issue environment clearance certificate in his favor. Paragraph Learned Counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph, let the matter appear under the same heading on 10th May.
10th May.
My lord, little longer. My lord, can you come back on 16th?
Very well, come back on 16th.
15th.
He's asking for a little more time. 16th May. Please have an advance copy.
My lord. My lord, I can.
Should it be a pattern? No.
Short order, but not.
My lord.
Great.
Number 30.
Judgment of
30.
30 Maladam for the petition. Judgment in this case, my lord, I have applied for the long-term mining lease, my lord. What happens, my lord? Here also, previous to that, my lord, I state something that when I filed the REIT application for long-term mining lease, there was a provision amended in 2002 rules, that is 16A and 16B. My lord, I moved a REIT application before the Honorable Court, but the REIT application was dismissed. Now, my lord, I preferred an appeal before the division bench. My lord, come to page 16, the judgment of the division bench.
16.
16.
Yes. Yes.
Now, my lord, come to page 18, my lord, para 4, at the bottom, the main part. Be that as it may, the law is well settled in this regard until the order passed by the lead court declaring these two provisions as ultra vires set aside by the Honorable Appeal Court. The law which has been laid down by the lead court in the said decision will be the law of the land, and the rights of the parties at large will be governed by the principles laid down by the lead court in the order dated 4th July 2000 past in the region such and such. It also be kept on record that though such an appeal was filed, but no interim order was yet been passed by the Honorable Appeal Court, staying the operation of the order which is two amended provisions of the West Bengal manual were declared ultra vires. My lord, what happens, my lord? My lord, ultimately, in the our division bench, on the month of March or May something, my lord, it had already been dismissed. The appeal has been already dismissed. Now, my lord, what happens, my lord? Hearing, next page, my lord, come to page 20. On the basis of the judgment, a hearing was concluded. And next page, my lord, Annexure P321, on the basis of the same order of the Supreme Court, they stop everything, all the proceedings. My lord, I have applied for the environment clearance certificate But until and unless the map vetted by the additional district magistrate, I can't obtain the environment clearance certificate. When I come to page 28, P6, I obtain, what happens now, the district magistrate, additional district magistrate and district land and land reforms officer, yet came pending for vetting the map. My humble appeal before your lordship is that kindly vetted my map so that I can obtain the environment clearance certificate. My mining lease application was 5 years, no doubt of it. Only my humble prayer is,
For vetting.
for vetting the map. Let the direction be given to the additional district magistrate for vetting the map so that I can obtain the environment clearance certificate.
Yes.
Not vetting the map in accordance with consider the vetting the map.
So let this representation be considered. That is your prayer in the.
Yes.
In accordance.
Affidavit of service.
নামটা দিয়ে দিই।
The lease is granted? No.
No, I have made an application.
The petitioner applied for grant of long-term mining lease for the concerned authority
For 5 years.
for a period of 5 years, which was rejected on the ground of the amended provision of the West Bengal Minor Minerals Rules 2002. Stop. A writ petition filed by the petitioner against such rejection was dismissed as against which the petitioner preferred an appeal, being MAT number 947 of 2014. Stop. By an order passed on 22nd December 2014, 2014 in the said appeal, an honorable division bench of this court allowed the prayer of the petitioner on the ground that the amended provisions referred to were declared ultra vires by a writ court. Pursuant to the said order, the petitioner applied before the concerned authority, being the district magistrate Bankura, for vetting of the map. Vetting of the map submitted by the petitioner before the authority. Submitted an application before the concerned authority, before the district magistrate on 16th November 2016, authority, which has not filed an application. The petitioner filed an application before the being the district magistrate Bankura on 16th November 2016. Before the authority, which is yet to be considered. Stop. The petitioner pays for a direction of the authority to consider the application at the earliest. Paragraph, it is submitted on behalf of the respondents that the fourth respondent be directed to consider the application in accordance with law. Paragraph in view of the above, the disposal of directing the court respondent to consider and dispose of the application submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law, to all the interested, to all the stakeholders, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week there. Disposed of, etc.
Lordship, Lordship, may I allow to submit? Lordship, I'm appearing on behalf of the petitioner. Lordship, I'm playing a 1 week adjournment. The other
34 has not been called. Then, no, you mentioned.
Motion Rule 7, item number 184.
Not IPA for the petition.
Well, 184, my individual opposition may be kept with it.
Milord, the item number 184, Milord, Milord has become.
Affidavits were called for.
It was called for, Milord. Now, Milord, these petitions become because of item number 185. Because, Milord, in this petition, we have challenged, Milord, an order of termination. And we have also filed an appeal. During pendency of this petition, Milord, Railway has come up with the order in appeal. That order in appeal has been challenged, Milord, item number 185. So therefore, Milord, this item number 184, Milord, has, Milord, both the order has been challenged in the next item.
You were the petitioner in both the matters. So this has become infractuous. Let
Because
this
all-
be disposed of.
Yes.
The first matter.
In view of the, Milord, the petition, second petition.
Yes.
Not his matter, he is withdrawing, man.
Yes.
His matter, he is withdrawing.
Even if it doesn't withdraw, it is infractuous.
And on last day, my lord, I have also raised that objection, man.
What is the order passed on June 24, 2019?
Milord, that was the order of termination. Milord, may. That order is.
Oh, your prayer D was for consideration of the appeal.
Yes, Milord. And thereafter, Milord, when this matter was heard, Milord, I have annexed the order in the next week petition. They come up and say, Milord, that they have disposed of it. Therefore, we have challenged the order in appeal along with this order in the next week.
So let me pass an order in this matter. Do you still intend to file this affidavit in opposition to this matter?
Yes, my lord.
Still intend to file the affidavit in opposition? in
Yes,
this
my
matter?
lord. Direction was there to, that may be kept with the record.
Help you in the second matter. No, it will be with this matter only.
So, my lord, then I have to file that matter.
Affidavit in opposition filed on behalf of the respondents is taken on record. Paragraph. It is in view of the submission made, paragraph, in view of the submission made on behalf of the petitioner, that the appeal has been disposed of by an order passed on
Milord, on 12th September 2019.
12th September 2019, and the said order is under challenge in a separate petition, comma. The present petition has become infractuous and is accordingly disposed of. Urgent certified website copy. Next matter.
185.
Here, Milord, this is Milord in
The
connection.
appellate order is
Yes,
challenged.
yes, appellate order along with Milord.
Along with?
Milord, the order of termination, because the appellate order has affirmed, Milord, the order of termination. Milord,
That is merged with.
yes, yes. Milord, the petitioner before your lordship was, Milord, a registered leaseholder of the railways. During the material point of time, the lordship can take, Milord, each 4 of them.
Got to come up with an opposition in this matter also.
Milord, this case is based on, Milord, the violation of principle of nationality. If I show, Milord, in one liner, the order in appeal. Milord, your lordship has indicated your lordship mind that page 132. Your 132. Your appeal is, Milord, cancellation in registration security has been examined and competently regulated. The order is. Milord, page 132. The
132 is the communication.
Yes, Milord, this is the appeal. This is the order. That is what they have, Milord, sir.
It is the order of appeal.
That is the order of appeal.
This is a communication.
Yes, that is the way, Milord, they have communicated. There is no reasoning. That's the ground for challenge, Milord.
You have not received anything else.
And it is not here, Milord. That is the only thing we have missed. And that was been handed over by my learned friend during the course of hearing of this, that earlier writ petition.
Yes, Mr. Ghosh. Where is the appellate order? This is a one minor combination which says that consider rejected.
And generally what happened, actually, they are the concerned authority passing their order in their file, in their, and that was the decision thereafter communicated only.
Without hearing the
So,
appellant,
yes, my lord. I think, my lord, that entire thing used to be communicated. Yes.
and whether the appellant was heard at all.
That has been admitted by
It is
my.
his appeal. So he has to be heard by the authority. Was that
My
done?
lord, I have no instruction that whether there any opportunity of
If you take
hearing
instructions
was.
from
Milord,
that,
here it just indicates in the earlier affidavit they have filed, Milord, in the earlier petition, they have admitted that there was no opportunity of hearing. My lord, you kindly see, Milord, that in paragraph.
So will you go for a reconsideration?
Yes, yes, yes. My lord, my submission is also that, my lord, before giving the punishment and in appeal, my lord, the person should be heard. It is also my submission. But actually, my lord, in the written, my lord, agreement, there was no such provision is there for giving an opportunity of hearing.
Is any provision required?
But my lord, I personally feels, my lord, at the time of hearing, person should be, my lord, give me an opportunity of hearing at the time of, at the time of disposal of appeal. It is, my lord, I personally think so, my lord. But my lord, in the agreement, my lord, there is no such provision for giving an opportunity of hearing personally.
Is there an opportunity of appeal in the agreement?
Yes. That is at page, my lord,
So many words that you be heard.
page 56, my lord.
So without wasting further time on this.
My lord, may I submit one thing?
Yes.
Let the direction may be given the appellate authority to hear, first hear the appeal by giving an opportunity of hearing.
Yes, yes.
Yes.
Let that be done.
Yes.
Raise your case before the appellate authority.
Yes.
Yes, Milord, I have taken only 2 points, Milord. That's the clause they have relied upon. My lord, also direct, Milord, the observe that they should not run a fresh case. Only, Milord, because the difficulty is.
No, no, my lord.
No,
That is only restricted regarding the appeal. Appeal.
and the
No
order
other
which
thing.
has already been passed.
Otherwise, my lord, then I have to come with an affidavit.
No, no. The only thing is that my lord will kindly see, Milord, the order of
No, 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 no.
Just a second, আমি কি বলছি?
What is your prayer? In the
Prayer is Milord consideration, but Milord, in the order of appeal, they have taken only 2 grounds. That reason at Milord, page 109. Milord,
the order of termination cannot be touched because it's the subject matter of appeal.
yes.
So let the appellate authority
Madam.
revisit your case.
Yes, appellate authority will decide that.
Time frame
App-
is 1 month.
Appeal is against that order, my lord, against the termination. So everything is kept
Let the
going.
appellate authority decide.
Yes, appellate authority will be decided.
The writ petitioner assails the order passed by the appellate authority
আর কিছু চাও? আর কিছু চাও?
on appellate authority communicated to him on 12th September 2019, primarily on the ground that the petitioner was not given an opportunity of hearing by the authority prior to passing such order. Paragraph. It advocacy appears that the decision taken in the appeal turning down the prayer of the petitioner was communicated to the petitioner by a letter issued on 12th September 2019 by the senior commercial manager slash senior commercial manager for the principal chief commercial manager and there is nothing on record to suggest that the petitioner was offered an opportunity of hearing before the authority prior to passing such order. Paragraph in view upon consideration, you are not disputing this fact.
Well, at least in earlier opposition, no such thing was stated that the opportunity of hearing was given.
Paragraph, in view of the above, comma, in view of and upon consideration of the submission made on behalf of the parties, comma, and this court is this court is inclined to hold that the petitioner ought to be given an opportunity of hearing before the appellate authority before any order is passed therein. Paragraph, accordingly, the writ petition is disposed of. Accordingly, the order of the appellate authority communicated to the petitioner, B-Day letter dated 12th September 2019 is set aside. Paragraph, the appellate authority being the respondent number.
Respondent number. Well, he is the principal chief commercial.
Three. Respondent number 3.
Being the third respondent here is directed to revisit the issue upon affording reasonable opportunity of hearing to the petitioner and also other stakeholders, comma, if any, comma, and pass a reasoned and speaking order within 1 month, within 1 month from the date of communication of this order, in accordance with comma, in accordance
Within 1 month from the date of communication of the order.
from the date of communication.
Milord, they decide the appeal, Milord, my termination be kept in appeal.
No, my lord. That cannot be.
It is
That is
pending.
under challenge in the appeal.
Yes, so please do not terminate till the appeal is disposed of.
No, my lord. He was challenged, the termination of registration, cancellation of registration, he is challenged before the appellate authority.
Yes.
So appellate authority will decide everything.
Yes, Lord, but
Yes.
what I am seeking, Milord.
How that
they
would be kept in
appeal,
abeyance?
not
No,
in
my lord.
given
Then, my lord, kindly hear me.
Let there be no coercive action till the appeal is disposed of, otherwise the appeal becomes
Yes, my lord. Appellate authority will dispose of the appeal.
Let there be no coercive action till then upon the petition.
My lord, action is already taken. His registration is already cancelled due to overleading more than 4 occasions, my lord.
Very well, come back.
Yes, my lord.
Let
I am
there
very
be-
fairly submitting, my lord, that no opportunity of hearing was given for this reason, my lord, that
the decision taken by the appellate authority shall be communicated to the petitioner within a week there.
yes, ma'am.
Disposed of exactly.
Yes.
Next.
On 86.
I have heard.
It. You have been implicated as a party in this matter?
Yes, respondent 6, Lord.
Who is appealing for the state? State?
State I have sought.
Your affidavit of service is also not there. Devra, So, Devra, are you appealing in this matter?
I am not in this matter.
You're not in this matter? Where is your affidavit of service?
Nothing in course of this day.
Allow it.
I cannot hear you. It was made not today, yesterday, isn't it?
Not for the on ground. I tried to solve about Mr. Sina on the last.
The Sinha is here, that problem is solved. What about the state? Show me service. Then only I can request him.
I have solved it. Typical service in course of. No.
Mr. Devra, may I request? Order will be reserved till you submit your affidavit of service. Okay? Same order?
My lord, the same order division bench reflects.
That is recorded in this order.
Do you have a copy of the order?
That's a problem for.
My hand over one copy. All right.
Last order.
এটা আপনার তো
এটা হবে।
বিঞ্চিটা দেন
এটা হবে।
সার্ভিস দেন সার্ভিস ওই করে দিই
এখানে শুরু
আরে এখানেই তো করে দিই
Three. Director, Transport Director. ক্যানটা হবে না, এই হয় রানের প্রসেস থেকে সবগুলো আপনি নেবেন এর মধ্যে। এটা সার্ভিস ফাইল বাই দ্য পিটিশনার is taken on record. None appears for the state respondents despite service. Mr. Debra, who is present in court and usually appears for sale.
এগুলোর জন্য একটা রিপোর্ট রুম রাখতে হবে
করে তারপরে এই অর্ডারটা করুন।
এত
কিন্তু এটা প্রিন্ট করে রেখে দিন, এখানে পাঠাবেন না, উনি যেটা দেবেন তারপর আমার কাছে যাবেন। I'll wait for your affidavit of service. I'm passing the order, but I'll wait for your affidavit. Mr. Debra, I'm recording your name. Mr. There, along with a junior of his choice, bole Mr.
Same.
I'll score.
187.
Yes, but in this matter, I'm appearing on behalf of the petitioner. I have already served the copy to the respondents as well as Mr. Sinha. Ability to submit. And
This is party, yes, party.
yes. And my lord, 13 January I have challenged, 13 January and 13 July, pagination, my lord, page number 59 and 126. And response number 3, Director of the Waste Department.
Service, Mr. Deyasan.
My lord. Next matter.
Next.
No, 188.
Same identical, I have served the copy, Mr. Sinha as well as Mr. Debrai, appearing on behalf of the state. Yes, my lord. Every service, my lord.
I am appearing one.
My lord, 13 January, my lord, section, page number. Yes. Yes. You don't know what page, right? 13 January, I have annexed, my lord, in this situation.
ও থাক দেখতে হবে না
বলে দিচ্ছি সেম my lord. ওইটা কালকে থাকবে, কবে থাকবে এটা, কবে থাকবে? 3 তারিখ।
কনসেন্ট করে দিচ্ছি এতে রিটেড
189.
না অ্যাপিয়ার করলেই তো
সই করে।
ঠিক আছে।
189. Have you served?
ওই ম্যাটারটা।
Yes.
But this matter, my lord, that immediately after my lord submitting an application for permit, state carriage permit before the State Transport Authority, now my lord, they have filed this writ application on the ground that the application is still pending. Now my lord, during pendency, my lord, the intimation is that tomorrow is the date for my lord, the matter to be placed before the board for consideration, and applicant has been asked to appear. So my lord, recording the said facts, matter can be disposed of.
Only one thing is that what they do while considering the application, they have taken instead of complying section 21. They are.
No, but what they will do tomorrow,
First came, first out basis.
let them consider
Cause of action. for
separate cause of
Let
action.
them,
Let them discuss. The petitioner has prayed for a direction upon the concerned authorities to consider his application dated 23rd February 2023 for grant of stage carriage permit. Paragraph which is submitted on behalf of both the parties that the application has been fixed for hearing on 28th April 2023 and the petitioner has been served with a notice
Oh,
there.
28th April, on 28th Friday. Jumawar.
Paragraph in view of the
ওই দিনই রাখে।
same, comma, nothing further remains to be adjudicated in the writ petition and the writ petition is accordingly disposed.
Right.
Urgent certificate proceedings.
Disposed.
190.
Yes.
I have received a copy from my learned friend. Your Lordship, kindly take it up next week, my lord. May I go through
What
the.
copy have you read?
It was not by the, if hand over a copy, but handing over to my lord. But it is- Lordship, kindly-
This is against the illegal fake registration and fake registration authorities have galore and operation of those vehicles in area. Well, I raised objection. Well, they have taken into consideration. It is in process. Let me go through the report, madam. May I come back next week?
And also, you know, they have made a thorough inquiry and.
Yes, yes, yes.
Concerned police officers.
Yes, yes.
They were in.
A similar matter was disposed of earlier also. I think.
Well, next time your lordship will raise it.
Come.
I'm getting it.
Affidavit of service. Instructions submitted paragraph. With the affidavit of service. Instructions submitted on the respondents is taken on the record. Paragraph on prayer of the petitioners, the matter is adjourned. With the- 12th May.
I'm extremely grateful, Lordship. When yesterday also I could not attend without my lord's hearing.
Number 191.
I'm happy.
Yes, service not complete, but there are private respondents. Since after vacation, since service is not complete, let the matter stand over till
Next,
16th May. But month is.
One eight one. No, monthly, monthly. 51 thing, monthly, combined. Regarding this matter.
Petitioner.
No,
Number 951.
I am bullying next. You will remember, Lordship, on previous day, my lord, item number 950 was called. The matter was hard at length. Lordship will remember the matter pertains to erection of 5 JMU stalls. Jana hard, Lordship. There were 5 identical matters, my lord, appearing from item number 950 to 954. Lordship was please.
But come back with a.
No. No, Lordship has already passed and extended.
Fixed on 13 June month.
Lordship has extended the interim order
till 30th of June and returnable date has been fixed on 13th June. So this order, Lordship, has to be passed in respect of other 4 matters.
Similar matter.
We have all forgotten to indicate this particular aspect before the Lordship. Yes.
Yes, sir.
My learned friend forgot, everybody forgot.
Wanted to come back with instructions or something. There was
Lordship has pleased to give me a liberty to use a supplementary affidavit because I have paid the entire license fee.
You want to come back with
I want to file a supplementary affidavit. My learned friend sought a liberty to file any report if there be any against me. But prima facie, he could not show any negligence on my part yesterday. But this was the order, Lordship, to be passed on 4.
learned counsel appearing for both the parties. Counsels, appearing for both the parties, submit. Matters pertaining to the similar issue as in the present petition have been fixed for hearing on
13th of June.
13th June 2023. Paragraph ND of the same. Let this matter also appear under the same heading on 13th June 2023. Paragraph on prayer of the petitioner, liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, the interim order granted earlier is extended till 30th June 2023 or until further orders, whichever is earlier.
Lordship, a similar matter, a similar order, Lordship, in respect of till 9:54. Right? Similar matter.
52, 53,
54, similar.
951 to 954, same order. Yes.
Grateful, my lord.
952.
Same, my lord.
Same.
954, same.
54, up to 54.
State.
Monthly
These matters were not expected to be called. So Sardik Bhattacharya, he repeats there every day.
Better kindly make it not because every day he comes.
Every day is there.
His junior also here.
Go for the state.
Yeah, with the
You
state.
wanted to come back with a report.
What is the just for 3 or 6 time to my submit a report. So 3 is the Jharkhand my lord case.
For 3 is Jharkhand. Jharkhand is also not there. The lady appears for Jharkhand.
Yes.
It's not there today. None appeared for the. And no, I'll give a date because a report is also called. None appears for the petitioner and the third respondent. Paragraph, let the matter appear under the same heading on 15th May. Paragraph. They would be submitted by the third respondent on the adjourned date positively upon service of advance copy to the petitioner. Put in the form of affidavit.
956.
About the statement.
956.
I beg to appear for the petition. I beg to appear. My lord, the petitioner, my lord, owner, as well as the permit holder of my lord, the auto rickshaw
My lord, the route is Mohish Goat to Rameshwarpur. My lord, it is the area of my lord, the Behala route, my lord. My lord, in this route, my lord, there are so many. My lord, I have, it is my affidavit in service, my lord. Auto Indian. Auto rickshaw. Number 66.
Yes.
My lord, there are so many, my lord, the magic van and my lord, the Toto are, my lord, going on without any valid permit. And my lord, not only they are going on, my lord, they are so much, my lord, disparate in nature. My lord, they are registered to, my lord, take the passenger to the auto rickshaw. And my lord, it is also, my lord, very shocking, my lord, that I have, my lord, made a, my lord, the RTI application and the reply of the RTI page number 57 and my lord, page number, my lord, 60, my lord, 6, my lord, where, my lord, two are 66 and my lord, page number, my lord, 57 and 66, my lord. My lord, both the RTO in reply of my RTI application, my lord, both the concerned RTO, my lord, authority, my lord, replied that they have never, my lord, permit authority and they have never issued, my lord, this type of, my lord, magic fan. My lord, it is also, my lord, very unfortunate that after filing this writ petition, my lord, this a batch of, my lord, the group of all these, my lord, this the auto rickshaw, my lord, this permit holders, my lord, has been, my lord, assaulted. And my lord, I have also, my lord, made the several complaint, my lord. And my complaint before your lordships, my lord, this page number, my lord, this is a concerned RTO. That is, my lord, this 44, my lord. Just for take.
And I do support the words of the citizens. Yes, 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 yes.
The grievance is against some stranger, my lord. But against whom, sir, we shall take step, my lord. Well, it is not any for person, my lord. My lord, this type of, my lord, illegal, my lord, this driving and this authority, my lord, the resistance of the valid permit.
Has been issued, no registration has been done in.
My lord, my lord.
So, the authority to deal with your.
My lord, RT authority, if my lord take the.
Since that I have not issued.
But my lord, in this type of the resistance, my lord, I have faced, my lord, and even there is a, in that locality, my lord, every day.
RTO is responsible for issuance of registration.
My lord,
right?
my lord.
They have put up their hands and they have said, we have not issued, it is
My
not
lord,
our responsibility.
my lord, my lord.
So now the police authority should.
Yes,
know.
my lord, if your lordship, my lord, police, I have made the complaint. But my lord, if the RTO authority, my lord, made any, my lord, this, my lord, order, my lord, if, my lord, they will not, my lord, issue any type of, my lord, this authority and this, and my lord, this type of, my lord, this driving of the Irish van or magic van or Toto, my lord, is completely illegal. My lord, on the basis of that, my lord, order, my lord, I may execute, my lord, if your lordship.
Have letters in support of your contention?
My lord.
saying that they have not issued?
My lord.
That should be the proper forum.
Yes, ma'am. But my lord, RTO authority, if my lord, they my lord just dispose of my,
Responsibility. We have not issued. What further can they say? What more can they say?
my lord,
The authority cannot come and stop. replying
no,
of
no, my
payments.
lord, they have not, my lord, they have not, my lord, issued.
That is for the administration to do. isn't it?
But my lord, this type of is going on.
Please approach the administration without, because this court cannot help you here.
So my lord, if your lordships, my lord, admits direct, my lord, if your lordships, my lord, subject to your lordship, my lord, just direct their.
It's for the state in other matters. In this, he's appealing for the RTA.
Yes,
So he cannot be given a blanket direction.
no, my lord.
You have your for a different forum to approach.
Yes, my lord, I have, my lord.
Withdraw. I'll grant you liberty.
My lord,
The police authority has to take stringent steps.
but my lord,
Menace.
but my lord, RTO has a authority, my lord, to my lord, complain before this, my lord, administration, my lord. Because if the RTOs, my lord, just hold his hand, my lord, that is RTO has a power because to just to.
Case of fake registrations. Here, there are no registrations at all. That is your case.
But my lord, the persons without any permit, my lord, going on.
Fake registrations, fake permits.
My lord.
That is duping the RTO authority.
My lord, my lord.
So there the RTO authority has a role to play.
My lord, my
You
lord.
can say that they have not issued this, it is fake, so the police can take action.
My lord, fake,
But
fake.
here they have not issued anything, there is no document also used.
My lord, fake permit and without permit. My lord, those are my, my lord, those are even the same. But my lord, if your RTO, my lord, made an, my lord, information to this administration, that will be, my lord, more, my lord, powerful for the individual approach before this. That is why my grievance, my lord. Kindly, my lord, direction.
Since my
That
response
is
6
mine.
is also appearing, my lord, auto rickshaw operators union. Yes, yes, my lord. Let my lord, union, my lord, approach before the authority, police authority. And if the police not taken in step, my lord, then
If your lordship, my lord, forward this my submission to that RTOs admitting this, my lord, this type of going on is, my lord, completely illegal. That is, my lord, helpful to me because the authority, my lord, is.
Sir, admit or deny.
Well, that is the illegal.
In the shoes of the RTO.
My lord.
You have not issued license to anyone.
No, my lord.
There is some allegation against someone. Are you in a position to either accept or deny?
No, my lord. But this is.
Please say, I have not issued any license for these vehicles.
My lord.
That's all. So how can?
But my lord, if my lord, the RTO, my lord, made any, my lord, this.
Your case is not a fake.
No, my lord. No, my lord. No, my lord. Without. No, my lord. Without any authority, my lord, if the, my lord, there are, my lord, so many route, my lord, has been classified that this route, my lord, Toto is going on or auto is going on. That is, my lord, my lord, this one classified. But if, my lord, the RTO having the knowledge, this type of even not, there is a assaulted by this. My lord, kindly, my lord, RTO make the information that this type of the authority concerned, my lord, the management.
Knowledge.
Well, because, my lord, the reply the RTO. Reply, my lord, in my RTI application, my lord. Well, they have, my lord, admitted that I have no,
Issue.
my lord.
How do they have knowledge that there are several vehicles which are applying?
My lord, it is his knowledge, my lord, because it is CCTV is going on. My lord, I have made the several representation.
For the police to see.
My lord, 40, my lord, my page, my lord, my application is 40. My lord, my page, my application is 44, my lord. That is, my lord, made before the RTO, my lord. So, my lord, they have made the knowledge, my lord. Even, my lord, they have a authority to make a investigation, the whether this type of going on or not. That is my, well, for individual approach and, my lord, for a, my lord, this authority, my lord, made a information to the administration, my lord, that is a huge difference, my lord. That is my.
What is your request? Please stop running illegal auto. How will the RTO stop running?
My lord, this intimation and praying for the proper justice against the illegal act done by the owners and.
The prayer portion. In these circumstances. Mr. HON'BLE, I can just suggest disposal of this application by the RTO.
Yes, ma'am.
My lord.
Yes, nothing more.
My lord,
Let them take a decision.
my lord, my lord, my lord. Because my lord, any my lord order that will be helpful, my lord, to me, that is
The RTO to intervene.
my lord,
Let them just consider your.
my lord, my lord, my lord, that is. It is. Yes.
Aggrieved by illegal flying of illegal flying of photos, magic vans and Irish vans, IRICH, Irish vans without any valid permit. The petitioner submitted an application before the transport of the third respondent, RTO.
My lord,
The regional transport office,
my lord,
Beltola, being the third respondent hearing, on 16th December 2022, which is still pending. Stop the petitioner pays for a direction upon the authority to consider the application and take necessary steps in this regard at the earliest. Paragraph. The counsel for the sixth respondent supports the contention of the petitioner. Paragraph. Upon consideration of the submission made on behalf of the parties, the petition is disposed of, directing the third respondent to consider and dispose of the application made by the petitioner dated 16th December 2022 within 1 month.
yes,
Within 1 month from the date of communication of this order. Upon affording reasonable opportunity of hearing to all the affected persons, including the petitioner and the private respondent, in accordance with law.
my lord, may I one thing, my lord, the RTO Behala, my lord, there is a.
Yes, the third respondent, RTO Behala.
My lord.
Beltola, you pray. Not Behala.
Behala, my lord, is the local, my lord, and Beltola is the
Fifth respondent.
my lord.
That is. Fifth respondent.
My lord,
For the regional transport office Behala.
Behala.
Regional transport office Behala. Being the fifth respondent.
My my and the
It's
957. I'm for the petitioner, my lord.
I'm for the Union of India Postal Authority.
yes, you wanted to take instructions.
Lordship, may I place my instruction
Have you served the copy, the petition?
and acknowledge? Lordship, look at the page number 1, my lord.
What is the matter about?
Third paragraph, my lord.
My lord,
Madam, bole যাচ্ছেন shortly.
my lord, the deceased father during his lifetime on 10th May 1994 entered into an lease agreement with the postal authority in respect of a Shikarpur post office, my lord, at a rental of rupees 1,500 per month, my lord. But during the subsistence of that agreement, the father of the petitioner died on 29th October 1995. And upon the demise of the father of the petitioner, the authority started paying the rent unto the mother of the petitioner. And subsequently, my lord, the respondent authorities communicated a letter dated 14 November 2003, thereby intimating that without entering into any agreement, the authority cannot payment the rent, my lord. As a result of which, my lord, on 17 December 2003, entered into an agreement at a rental of rupees 1,500 per month, payable in accordance with English calendar month. Duty and that agreement expired on 16 November 2008, my lord. And my lord, till date 2008, my lord. And thereafter, my lord, the authority is paying rent without entering any fresh agreement till January 2009, my lord. Thereafter, my lord, in the meantime, in the month of January 2009, my lord, the collector sent a notice to the petitioner, to the addressing to the petitioner and his mother that property is a vested property. Subsequently, the petitioner approached the civil court, and civil court decided that this property is not a vested property, and the petitioner is the owner. The petitioner has the title, interest, and possessions thereof. As a result of which, he is the owner, my lord. Thereafter, my lord, the petitioner approached the authorities approached for the payment of rent, my lord, which was due on and from the month of February 2009 till date, my lord. The amount of the rent is almost, my lord, 2,56,000 till date, my lord. My lord, as a result of which, the petitioner made several complaints to the respondent of 5, my lord, since he entered into the agreement on behalf of the government of India, my lord. And the authority, the respondent of 5, communicated a letter thereby intimating that the proceeding is under process, my lord. But till date, no payment has been made. As a result of which, my lord, the petitioner sent another letter through his learned advocate, my lord, dated, my lord, December 4th, 2022, my lord. And
You are only claiming rents.
rent, my lord.
You will not ask for eviction.
No, my lord, no, my lord.
Your lordship will find out. Go through the instructions and come back, or are you ready to do?
No, my lord, kindly, then my lord,
Lordship.
take it not to the, my lord.
Have you seen the instructions?
No,
I've given.
kindly-
Let us hear Paragraph 3, my lord, before our instruction, before completion of the said agreement, Srimati Shefali Bishwas has raised an objection in written on 9th June 2008, on whom the ownership of the Shikarpur building, mentioning Annexure A. Lordship, kindly next page. This is Annexure A. This is the complaint, my lord, filed by the Shefali Bishwas. Its office on behalf of the department started inquiry in this regard on 27th June 2008 by the Tehatto subdivision, that is Annexure in our with our instruction Annexure B. The department got the inquiry report from the BLLRO, right, memo number such and such, dated the 16th March 2009, that the land has been vested to the state government, that is our Annexure C, my lord, with this instruction. Sub Postmaster Shikarpur reported that the condition of the building was absolutely damaged on 28th August 2008. As per the report, the department took the initiatives several times to repair the building in all aspects. The owner of any associate of the owner did not cooperate with our department for repairing works, though the department informed the actual condition of the building. Sri Shapun Kumar Kundu, Advocate, Tehatto Court, and District Judge's Court submitted an application on behalf of his client, Sri Kishore Jodhwar, or petitioner, on 6th December 2017, that his client has filed a civil suit being 70S number 33 of 2013 before the Learned Civil Judge Junior Division at Tehatto, Nadia, on 8th March 2013 in respect of scheduled property against the state government, with intimation to this office on 19 December 2017, as well as BLLRO Korimpur, that is on
29 January 2018 regarding actual ownership of the said property. Then, my lord, the department got the information from the BLLRO, that is by memo number such and such dated 26 December 2018, that the matter is now under sub judice and informed to this office on 10 January 2018. It has also noticed by departmental inquiry on 16th April 2019 that the concerned land is vested to the government of West Bengal and the matter is now under judgment of West Bengal Land Reforms and Tenancy Tribunal. That is pending, my lord. In land.
No, my lord, that has been, the judgment in past. Yes, I have annexed this.
কোথায় দিয়েছো?
Annexed করে দিই।
কি annex করেছো? Land Tribunal order annex করেছো?
No, my lord, I have no instruction.
আমাদের instruction আছে. He has not made.
The documents, what is pending before the land?
Lordship, he has not made the BLLO a party, my lord. BLLO should be party in this petition.
What is pending before the tribunal? Please show me. The civil suit has been disposed of.
16th April 2019. Land reforms, it is sub judice under West Bengal Land Reforms Tenancy
What
Tribunal.
is pending? Please show me.
That documents I have to get from my clients. And another point, my lord,
Made
please.
submissions here which and without support. without
Lordship.
supporting documents.
Another, lordship, kindly see page 10 of our instruction. This is the lease agreement. His father's name is Krishna Prasad Jordar. But my learned friend stated in his petition, Kishore, just 1 minute, paragraph 1, my lord. Krishna Pada Jordar. That is mistake tomar bodhay na eta?
পাচ্ছি না, নেই তো।
কি পাচ্ছ না?
কোথায় instruction আছে আপনার? কি করতে পারবো?
করো।
না, এটা আপনার ইয়ে কইছে। একটা slip আছে।
এই যে লাস্টে 10 নম্বর টেক্সট এইটা হ্যাঁ, এই যে নামটা দেখো না,
কৃষ্ণপদ জোয়ারদার।
কৃষ্ণ প্রসাদ এগ্রিমেন্টে কৃষ্ণ প্রসাদ।
কৃষ্ণ প্রসাদ।
তুমি
না না, কিশোর জোয়ারদার is the petitioner. Krishna Prasad is the father. That was entered into my lord May 10, 1994.
কৃষ্ণ পদ, that is ভুল না, নামটা ভুল আছে।
You have to make necessary corrections. Or grant a legal.
And he should make party BLLRO, my lord, because BLLRO in this matter related. BLLRO informed us, Postal Department, that case is pending. Without asking document from BLLRO, how can I get in my custody?
No, my lord, I have no
Lordship,
instruction.
kindly,
That's why, my lord, I need to.
kindly add BLLRO.
What is pending to the tribunal?
No.
I'll adjourn the matter. On prayer of the official. Liberty is granted to correct the name of the petitioner's father in the constantly of the petition. Paragraph. Written instructions submitted on behalf of the respondents. is taken on record. Paragraph. The petitioner seeks to take instructions with regard to case pending before West Bengal Land Reforms and Tenancy Tribunal as indicated in the report, as indicated in the written instructions. Paragraph. And after making in June.
I'm grateful, madam. To the ages of
958.
On this matter, I am appearing in matter of behalf of the petitioner. Along with Mr.
Affidavit of service. In this matter, I may.
আমি আগে বলে দিই আমি পিটিশন।
I made an application for being added as party respondents in this proceeding as a necessary party. The application possibly
It is
in the
not
file.
File, can.
Can touch.
I'll just find out. Give me 2 minutes, I'll just find.
Can touch it to Mr.
Have you received a copy?
Yes, I have already served copy.
Do you have any objection to it?
No, no objection.
So let it be allowed.
Is a timetable matter, my lord? If you were here,
I'll just
not-
take that.
Not necessary.
Although the existing operator no longer standby, although my lord, it is not necessary that the on merit is give the order.
Yes, acha application.
Lord, your lordship kindly, have your lordship got it?
It is there.
Yes.
They'll give it to me. Please, continue.
Just please in the matter.
Let us continue the
My
hearing.
lord, we are holding the man of permanent stays.
Your application is allowed.
Yes, my lord.
Well, kindly see the page number 12. We are holding a permanent
12,
stage carriage permit
12, 13,
I mean,
14.
that's on the route, my lord. We have the three read petitions, the three permit holders. Page number 12, my lord. The petition number 1 is holding my lord permanent stage carriage permit on the road Holdia to Mejogram via NH 41 Mecheda railway station. Route length total 87. This permit was valid till 6 March 2027. My lord, got it?
Yes.
Next page, kindly see the next page, page number 13. The petition number 2 is holding the permanent stage carriage permit on the road Holdia to Mecheda, serial number 3 via NH 41. His permit also valid till 1st June 2026. Now can you see the next page, page number 14. The petition number 3 holding the permanent stage carriage permit on the route Holdia to Kolaghat via Mecheda railway station and back. My lord, according to the Motor Vehicles section 72 of the Motor Vehicles Act, if vehicles are used on a specified route, and my lord, the vehicle shall be commenced to ply on the roads from the date of specified date, from the date of grant of permit, and the timetable and fare charge the condition of permit. Timetable must be exhibited. Individual timetable will be issued, must be executed in the vehicle. There is the condition of permit. Violation of permit condition, permit liability to be cancelled. So, my lord, initially, my lord, individual timetable was issued against the all permit holders. Now, my lord, after few months, my timetable has been incorporated in the consolidated timetable, page number 18.
Number 18.
18. At least 66 vehicles have been incorporated, combined in the single unit. And this timetable was issued on the Holdia to Mecheda. Our route, my lord, Holdia to Mechogram, Holdia to Mecheda, and Holdia to Kolaghat. This consolidated timetable has been issued only on the route, top, my lord, at the top,
Yes.
Holdia to Mecheda. All those operators, except we are two operators, all those operators who are plying the vehicle on the route, Holdia to Mecheda. Our permit up to Mechogram, Holdia to Mechogram, Holdia to Kolaghat. Only one permit, that is petition number 2, holding in the only on the route, Holdia to Mecheda. According to the Motor Vehicles Act and rules, the individual timetable must be issued and must be executed in the vehicle. Our vehicle has been incorporated in this timetable. Only. But this timetable cannot be executed in the vehicle because consider timetable. 66 operators have been included in this. It's not. So we have met the representation. Kindly see the page number 34. Page number 34. We made a representation requesting the Secretary RTA to issue individual timetable as part the timetable mentioned in the consolidated timetable dated 5th November 2018, along with proposed timetable, page number 35. We have made these representations made along with my proposed timetable, page number 35. All the bus owner association has already signed in this proposed timetable. They have no objection if this timetable was issued. Next page, page number 37. Again, we have made the reminder. This is the petition number 1. And next page, page number 37. This is the representation of the petition number 2, along with proposed timetable. Here, my lord, the association of the bus owner association, given the no objection. And page number 40, this is the application of respondent petition number 2, 3, along with proposed timetable. Along with proposed timetable. And page number.
So you're asking for issuance of individual.
Well, page number 43. The Purvo Mendipur Bus Owner Association also requested the secretary either to renew consular timetable or individual timetable. There's no objection. So I have brought 2 judgments on this issue. One of the same issue raised in the year 2005 after bifurcation of the district, 2 districts. My lord, the association requested of the authority, recommended to issue the rotational timetable to ply the vehicle with adjustments. One of the operator came before this honorable court. That time, my lord, I appear on behalf of the RTI. Now I reverse a change of government. So, my lord, I made the representative. I made the affidavit in opposition on behalf of the state government. In the affidavit, I said so. There is no provisions of the rotational timetable because individual timetable must be exhibited in the vehicle for the convenience of the passengers. So, well, I'm placing the judgment also.
Let us hear the respondents. If they do
Yes, sir. But I am praying for individual timetable.
do not concede to your submission, I'll go through, I'll see the judgments.
But there are no provisions of rotational timetable.
My lord, I think it is a third round litigation. Lordship clearly see. My instruction only paragraph 7 and paragraph 9 only, not go through the. No. There are so many buses. Then there are 73 number of buses operating in the city. And in view of the High Court's order, there district magistrate, my lord, hearing was took place, and also consolidated timetable was displayed.
But your report is silent with regard to the fact as to why individual timetables have not been.
No, that is not silent. That's why I kindly see paragraph 11. After getting objection, you consider timetable and on taking proper action for binding solution. As soon as the full proof timetable is prepared, this office is the opinion of individual timetable for every week.
Yes. But this is against the law.
You are. No, he's agreed.
Yes, individual timetable.
So can you show the direct authority?
Yes.
Nothing.
After obtaining objection from all interested parties, and lordship can pass order.
Your lordship kindly hear me.
All interested parties at the time of hearing.
Let us hear
Your lordship kindly see my application for addition of party. I have annexed your lordship's order. Make the position clear. Page 9. There are 76 vehicles who are flying on the road initially. Subsequently, the authorities fixed the consolidated timetable with the 66 vehicles, and the 10 vehicles were excluded from the set rotational timetable, and there was some disturbance regarding flying of the vehicle because the 66 vehicles were allowed to fly 3 round trips, 10 vehicles were allowed to fly 2 round trips, for which they moved the application before your lordship, and your lordship passed the order on 22nd November 2022, page 9, annexure P1 of my application. This is the order passed by your lordship, based on which the authorities prepared the consolidated timetable and directed all the vehicles to fly on the route as per annexure P2, page 12. They have granted. After grant of consolidated timetable for all the vehicles for flying equitable equitably. Now the three operators of allied route make this application to disrupt this consolidated timetable. But by submission, yes, my lord, I am coming to that, my lord. I have heard the submission of Mr. Khan. Mr. Khan said that there is no provision for grant of rotational timetable. The statute says for issuance of the timetable, it does not be indicated whether it will be individual or it will be a rotational timetable. My lord, on this aspect, my lord, against the decision of the single bench, matter is pending before the division bench. I move the matter before against an order passed by a single bench on this issue that there is no provision for grant of rotational timetable against which appeal was preferred. And that appeal is still pending before this court. So the issue is sub judice before the division bench, whether the individual timetable can be granted or rotational timetable can be granted. But there are several decisions on this point. There is a single bench decision also that only the equitable timetable may be provided if rotational timetable is granted to the vehicles flying on the same route. But there are decisions. Well, there are decisions. Now, my hum.
I appear on this matter. Because by the 2005, no stay. After 17 or 18 years, he has not taken any step or order.
Against the order.
Appeal was taken against the order. Was settled.
Yes.
In this court directed all the RPA to issue the individual timetable. They are the direction of the Honorable Court in terms of section 72. Again, this is a stay, no stay.
And the division bench is dealing with rotational timetable.
Blood, I am not on that point. Only thing they are trying to obtain the individual timetable on the basis of the timetable which stood lapse earlier. This is their only prayer. Issue the individual timetable in terms of the earlier lapse timetable, which was superseded by the present consolidated timetable in terms of your lordship's order. That is my submission. Your lordship's order is at page 9, based on which this individual timetable was granted by the authorities on 24th of January 2023, which is now prevailing in the field. They are trying to they cannot obtain the timetable according to their own convenience. If they want individual timetable, it is for the authorities to decide. But they are wanting individual timetable based on the earlier lapse timetable, which cannot be granted, which has been lapsed. They are pressing on it. It is for the authorities whether the individual timetable can be granted after issuance of the consolidated timetable in terms of your lordship's order. That is to be decided by the authorities. They made the prayer to issue the individual timetable on the basis of a lapse timetable, which was issued in 2018, which stood lapse in 2022. And thereafter, this present time, the consolidated timetable has been granted by the authorities. And except P2. Therefore, but I am not standing whether what type of timetable would be granted is for the authorities to decide. And so for the individual or rotational or consolidated, the matter is sub judice before the division bench. It has not been decided.
It is rotational timetable.
Rotational timetable.
But this is consolidated. This is not rotational timetable.
Yes, Lord. Your lordship is perfectly right. So for the rotational timetable, this matter is pending. Yes, yes. No, only my submission is that they can approach for individual timetable, but they cannot ask for issuance of the individual based on the lapse timetable, which stood lapse by a new consolidated timetable.
Absolutely wrong submission. We have the better with the proposed timetable. Proposed timetable along with my representation.
On the basis of the present timetable. On the basis of the present timetable.
We are applying them as per consolidated order. But now at present I am applied for the individual timetable along with proposed timetable. In consonance with the consolidated timetable.
They are already flying on the basis of the consolidated timetable.
Yes, Lord. So that time, the earlier consolidated timetable for 66 vehicles has been lapsed. It has been.
Not the earlier, the next one, the one which is present.
That present, my lord,
no.
applying the vehicle as per consolidated timetable.
No, consolidated timetable stood lapsed, my lord.
We have to submit the proposed timetable in consonance with the
See
consolidated
the petition.
Which time was fixed in the
Annexure P3 has stood lapsed, my lord.
P3 was valid up to October 2022.
Yes, it lapsed.
He chosen to incorporate in the consent timetable. I have no objection at all.
No, it
I
is to lapse. It is not.
problem.
Well, state advocate is there who can enlighten your lordship whether that is remain valid or not. After issuance of this
I am
timetable,
in support of the law.
please.
What is the
After-
subsequent timetable that is
After
being issued?
issuance of the first consolidated timetable for 66 vehicles, for 76 vehicles,
Where is that consolidated timetable?
that I have annexed in my application for addition of party, page 12. I have annexed it. Page 12. This was issued in 24th of January 2023. My application for addition of party, page 12. That is prevalent now.
We have moved the date on 24th March, long back,
24th of January.
24th of January. Yeah.
In any event,
We have met the-
this timetable is now prevailing in the field. It has been superseded by the earlier consolidated timetable. Therefore, if any step is taken based on this timetable, the authority has to take the
No, we have
take the steps.
filed
It
the
cannot
written
be.
status in the
It
month of
cannot be on
January.
the basis of
That
the last timetable.
consent time was valid. Therefore, he knew.
একটু দাঁড়ায়, হয় আমাকে বলতে দাও না তুই বলো।
You are missing the court. This is my bound.
You will get your turn. For his lordships, we will decide who is misleading the court.
I have to say.
Your lordship kindly see.
Misleading the
Ektu
court.
please, you complete, then I shall start.
Mr. Khan, please wait. Please wait.
But I am trying to assist your lordship that after issuance of this timetable, annexed P2, page 12, in superstition of the earlier consolidated timetable based on which they were applying.
Have no objection if the petitioners are granted individual timetables on the basis of the consolidated timetable of 24th January.
Yes, Lord. I have no objection. I have no objection. I cannot object.
What about the state? The state submission is also the same.
Yes,
There is already a consolidated
also
timetable
timetable.
on 24th January 2003.
My,
The petitioner can be granted individual timetables on the basis of this. Yes.
After hearing the other operators.
after hearing the
Existing operators.
If there is objection is received, then
Then
a class of
opportunity should be
class
given
of-
to them.
Class of timetable, objection of class of timetable.
Applications of the petitioner.
Lord, in that.
my lord, objection has to be invited.
Invited.
Page number
Objection
34.
has to be invited.
Page number 34. Onwards.
Before granting timetable, my lord, objection has to be invited.
34. Page number 34 to 42. 42. 34 to 42. But three operators,
43
three petitioners, and also my lord, along with the.
And man, your lordship will kindly consider one thing, that 3 lead petitioners have filed the petition jointly, who are the operators of allied route, not for the same route. And their cause of action to get the individual timetable is not the same. It is separate. Therefore, 3 lead petitioners cannot join in one petition.
Or a petition is maintainable on payment to individual court stamp, that is the judgment of the Supreme Court. I have brought the judgment also. I know that he will take this
The
point.
cause of action is primarily the same.
Yes, then.
But the individual timetable has to be granted individually. It is not the common.
No objection.
In that event,
They are all asking for individual timetables.
Yes.
individual, but they will get the individual timetable, not for by common order.
There has been a refusal to grant your individual timetable. Mr. Khan.
Not at all.
There is no refusal as yet.
Refusal, pending, my application pending before the authority.
The first prayer implied refusal.
Page number 34, this is the application.
Number 9, your first prayer, prayer A.
Where is?
To withdraw the implied refusal.
It has not been challenged.
It is not. been done.
Yeah, the rule nation have responded to it. Refusal to issue, because my application pending. Refusal to issue individual time.
There is no refusal. It is still pending.
Pending. Why did my
Implied refusal, if any.
No,
If any.
kindly, so consider that the authority to take decision on this, my application, which are pending before the authority.
After giving opportunity of hearing to the existing operators also.
Your applications are at page 34 is
42.
by petitioner number 1.
1, 2, and 3. One up to.
This one.
One up to.
37, 2.
One up to. My lord.
One has been.
36. 36.
One.
From 37 to. 39, petition number 2, and petition number 3, 42, 43.
34, 37 and 40, these are the applications.
Yes,
Let these three applications be considered.
3 applications up to 42, because petition number 1,
34, 36,
34, 37,
34, 37 and 40.
40.
These are the three applications.
3 applications. Yes. 3 applications.
Yes, let these
Mal-
be considered.
Yes, give some more time, Mal, because number of operators is there.
Yes. Affidavit of service. But let it process for the purpose. He can do. Huh? What is it? Can it go? Can one of them? The applicant seeks to be added as a party respondent to the petition. And upon consent of the parties, the application can successor is allowed. The applicant is added as number 4 to the petition. Paragraph, the content of the petition be amended accordingly. On this case of AWP, affidavit of service for learned counsels for the purpose. Yes. Submit. Permanent stage carriage permits were issued in their favor by the concerned authority. Which are valid up to 6th March 2027. Bracket petitioner number 1, comma. First June 2026, bracket petitioner number 2, and 10th March 2025, bracket petitioner number 3. Stop. A consolidated timetable was issued in favor of 66 operators, including the petitioners, which was valid up to 31st October 2022. A further consolidated timetable has been issued by the authority, including the petitioners therein, on 24th January 2023.
Or 76 vehicles.
Yes.
Or 76 vehicles.
76 vehicles.
76
In
vehicles.
respect of 76.
10 were added.
Huh? Vehicles, support including the petitioners. On 24th January 2023. So the petitioners made applications before the concerned authority for issuance of individual timetables in their favor. Applications developed on 18th July 2020. 18/19 July 2020. The petitioners made applications for Not made by the petitioners, and tables in their table, which are yet to be considered. Stop the petitioners. Pray for consideration of the said applications. Paragraph. It is submitted on behalf of the respondents that the applications of the petitioners may be considered upon inviting objections from other operators, comma, if any. Paragraph. The petition is disposed of, directing the who should be the authority? This is SUVRA, who should be the authority?
Yes, Lord. Secretary, my lord, secretary. Or given to secretary. Secretary, what is
Third respondent. Consider and dispose of the applications submitted by the petitioners dated 18th/19th July 2022. Bracketed pages 34, 37 and 40 of the petition. 34, 37 and 40 of the petition.
This was three.
Within 1 month?
Well, instead of 1 month, let it.
After giving
time to
opportunity has to be given to our existing operator, some more time is required. 2 months.
The objection, invited
6 weeks. 6 weeks.
6 weeks. 6 weeks. My আপনি তো বললেন 6 weeks. 2 months. I agree.
Within 2 months from the date of communication of this order, and consider grant of individual timetables in their favor on the basis of the consolidated timetable issued on 24th January 2023, upon inviting objections from other operators and affording reasonable opportunity of hearing to all the affected persons, including the petitioners and the objectors, comma, if any, comma, in accordance with law. The decision taken by the authority shall be communicated to the petitioners within a week thereof.
ওনাদের অ্যাপ্লিকেশনটা অ্যালাউ করেন না অ্যালাউ করেন প্রথমেই দাও মানে ক্যান ওয়ান ইজ অ্যালাউ হ্যাঁ ওটা প্রথমে বলে তো ওরা শুরু করেছে পরেরটা
Item number 959.
Yes, Lord. It is a simple matter for revision of timetable.
My lord, the timetable representation is there, my lord, better to consider to hear all affecting parties and to.
And my lord, page 15, I prayed for revision of the timetable.
Revision of time.
Of division of timetable, existing timetable, page 15 is the application followed by the requisite fees, page 16. Now the authorities issued a notice, page 18, 7th May 2022, notice was issued that to invite objection within 1 month. But no objection has been received by them. Your lordship got it, page 18. To submit objection within 1 month, no objection was received by them.
Over long back.
But the authorities have not decided the grant of revision and timetable, but asked me to apply on the basis of the earlier timetable. Well, in my humble submission, let the secretary, respondent number 3, be directed to take the decision for revision of timetable upon affording opportunity to, of hearing to me. The respondent number 3, secretary may be directed.
In fact, lordship, innocuous prayer apparently appearing for, but not so innocuous because others will be affected also. And my lord,
You have already invited objections.
Yes, well, nobody raised any objection. It has to be
that's a matter to be decided upon hearing.
Yes, yes.
Consideration of objections, if any.
Yes.
It's 2022.
Yes,
Yes.
within Milord,
1 month,
1 month.
1 month.
others are getting 8 months, 2 months.
ওটা
twice
বিগ
their
ম্যাটার,
rate,
ওটা
my client.
66টা অপারেট, এটা
Value it,
ইন্ডিভিজুয়াল।
Hearing the others' orders. Affidavit of service.
After receiving Milord this communication of this order.
Yes, that is obvious.
The petitioner.
Unless the communication is not, how can they act?
No, I am here, that's the communication also.
Normally আমরা করি থাকি।
Normally.
Holder of. This is a stage carriage permit.
Yes, stage carriage.
A stage carriage.
My lord.
అటు తారకేశ్వర్ మేడం. Route is not అటు తారకేశ్వర్. Stage carriage.
You have asked for a revision of timetable.
Revision of time.
Applied before the concerned authority on, what is the date of your application?
But the date is Lord. Next page you will also 23rd May 2006. Receipt source 24th of December 2021. Page 16. Receipt
My lord, it is,
regarding submission of the application. Seeking revision of timetable.
date copy.
24th December 2021 is the date.
Yes, 24th December 2001.
On 24th December 2021. Pursuant to which notice was issued by the concerned authority on 27th May 2022, inviting objection / suggestion / views / opinion from the existing operators within 30 days from the date of issuance of the notice. Stop. Paragraph, it is submitted on behalf of the petitioner that though no objection has been raised by any of the operators, comma, the application is still pending before the authority. Paragraph is submitted on behalf of the respondents that who should be the authority?
Milord, RTO,
RTO Bardhaman, Purva Bardhaman.
RTO Bardhaman. Purva Bardhaman.
That's for number 3, Lord.
This one number 2 or 3?
3 lordship, 3.
That's for 3.
Power is delegated, they can do.
Secretary.
Yes. In timetable dispute, delegation is there.
Consider the application in accordance with law. Paragraph in view of the above. The writ petition is disposed of, directing the third respondent to consider and dispose of the application submitted by the petitioner dated such and such.
In respect of revision of timetable. In respect of revision of timetable.
Applied for revision of timetable. Applied before the authority. For revision of timetable. Pursuant to which, no? Within 1 month from the date of communication of this order.
More time may kindly be given, if lordship, Milord, otherwise not, because they are waiting so long.
2 months, 2 months.
2 months, that will be all right, lordship, because
2 months will be, I am waiting for quite some time.
6 weeks.
Something in between, 6 weeks.
Very good.
Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all the affected persons, including the petitioner.
If any, my lord, if any.
And considering the objections, comma, if any, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Grateful, extremely grateful.
Very much. Now hearing matter.
Is it 3:30 fixed matter?
Yes. Yes, yes, madam. I led by Mr. Mukherjee, Shaktinan Mukherjee. He is on the.
Yeah, other matters released, subject should also place that not.
It will take.
Take some time. There are other matters are released for the day.
One thing I am, there's a 3:30 matter which your Lordship is not calling today.
I'm calling the 3:30 matter now.
Well, the hearing matter,
The other matter.
item number 1, well, only one prayer, let the matter retain his position, that's.
It has been written already.
I will not take a long matter. May it please your Lordship, Lord.
I appear for the KMD led by Mr. Kishore.
May it please your Lordship, I beg to appear, my lord.
এটাতে আসছে না।
হ্যাঁ?
ভিডিওটা অন করতে ভিডিওটা অন করতে এই জয় দেখছি বাসা থেকে বল ভিডিও অন করতে স্যার এসছে এখানটায় আসছে না তো এটা
এটা কানেক্ট হচ্ছে না, এটা অফ আছে।
এইটা
Please your Lordship, my lord.
Yes.
I beg to appear on behalf of the petitioner. On the last occasion, I had the privilege to take your lordship to a list of dates. A list of dates may be lying before your lordship.
Yes, yes.
I will not take your lordship through the list of date. I'll briefly indicate what is there appearing in the list of date. My client was the owner of several plots of land.
Yes.
In Mauja Pakuria in the district of Howrah. My lord, those plots of land were alleged to be acquired. Coming across that allegation, we moved a writ application before this honorable court. That writ application was disposed of by the Honorable Mrs. Pravish Shamanto. Kindly have a look at the date, only the date. Kindly, my lord, have a look at date.
It's 71 of the writ petition.
No, that was 18th of November 1996. List of date, my lord, page 3. We moved a earlier writ application on 26th August 1994. 26th August 1994. And that was disposed of by Mr. Shamant. In that writ application, there was an affidavit by the Deputy Secretary of the KMD admitting there was an acquisition notification under 4.1. As a Shamant held that where there is no requisition order, there cannot be any acquisition under 4.1. I relied upon a judgment of the Supreme Court, referred to in 1965 Supreme Court.
Last occasion I handed up to your lordship the copy of that.
I am not going to read it, I just beg to remind your lordship. That is 1965 Supreme Court, 1301.
Yes, yes, it's there.
Miller, that is a case, that's a judgment of the Supreme Court on Assam Land Acquisition and Acquisition Act. Kindly look at the top. We are dealing with West Bengal Land Acquisition and Acquisition Act of 48. The identical law was enacted in Assam. Your lordship will kindly turn to paragraph
4 and 5 probably.
yes, Lord. I'm trying to read out, my lord.
Paragraphs 4 and 5.
শুনতে পাবে আমারটা
4
শুনতে
and 5. Kindly
Sir,
compare
4 and 5
with our, my lord. Kindly recall our language. First a requisition and then an acquisition. Our section 4(1)(a) says only requisitions land can be acquired. 4(1)(a) uses expression only requisition land. In Assam also there was an identical provision. And in that Assam case, there was no requisition under Assam 1948 Act. There was a previous requisition under Defense of India rules. The Supreme Court held unless there is a requisition under the Assam Act, there cannot be an acquisition under the Assam Act. Only the requisition land could be acquired. Justice Shamanto in our case, kindly my lord, turn to that judgment. This is the Assam case dealt with the Supreme Court. Justice Shamanto in our case, my lord, the judgment is at page, my lord,
page 71
71. Yes.
last paragraph.
Yes. Not the last paragraph. Page 71. In the writ petition, the purported requisition has your lordship kindly got it.
Yes, yes.
Page 7. In the writ petition, the purported requisition of the lands of the writ petition are the provisions of the West Bengal Land Requisition and Acquisition Act 1948 has been challenged. The petitioner alleges the lands of the writ petitioners, as mentioned in the writ petition, are purported to be requisition under the provision of the said act without service of any notice and on the order made under the provisions of the said act in the to the writ petitions. So the state respondent had filed an affidavit, very important. Affidavit was filed. Affidavit in opposition to the writ petition containing the lands of the writ petition were acquired under the provisions of the West Bengal Land Requisition and Acquisition Act, but no order made under subsection 1 of section 3 for requisition of such of the same and or acquisition therefore of the said act upon in question have been disclosed. It is settled principle of law that nobody should be deprived of his property without the process of law, since there is no material either to show that there was an order of requisition. Therefore, order of requisition was not there. In this case, in the affidavit of opposition, there was a reference to a 4(1)(a) notification number is given in the affidavit in opposition. But his lordship held without a requisition, no acquisition can be made, quashed with liberty to proceed afresh. Kindly, my lord, have a look at it.
However, the order will not prevent the petition.
Yes, yes.
Last line, page 71, last line. My lord, it is admitted that pursuant to liberty, no further acquisition. It is admitted if it is disputed, I repeat it, I'm not going to waste your lordship's time. It is admitted that pursuant to this liberty, no further acquisition was. Now, after this, my lord, there was another gentleman, my lord, kindly turn to my list of dates. Page, my lord. Page internal, page 5 of the list of dates. Page 4 bottom. Page 4 bottom. When Ramchandra moved the writ application, that writ application came up before Justice Lala, and Justice Lala quashed it. I'm the same group, same 4(1)(a) group.
So will you please repeat the page number, please?
Page 4 bottom of the list of dates.
Page 4, list of dates, page 4, button 1988.
Yes.
Ramchandra Jaiswal. He moved, he belonged to the same area, my lord. He moved another writ application. That came up before Justice Lala at page 5. Justice Lala quashed it. Not only that, kindly turn to 2nd March 2001.
Yes.
দেখতে পাচ্ছেন এখানে নোট আছে তো কোশ্চেন তো
Yes.
2nd March 2001, the Deputy Secretary CMDA by his letter requested the Special Land Acquisition Office in Howrah Improvement to release the land. Therefore, first alleged acquisition, order of the court quashing the acquisition. Then, my lord, the CMDA is asking, my lord, the Howrah Improvement does release the land. They have been quashed. That is on 2nd March. In this instant writ application, we are only asked for a formal order of release, not the quashing of any acquisition order. That has been done. Only saying that in the records of the KMDA, in the records of Howrah Improvement Trust, the land still stand as acquired land. But in fact, Lord, order of acquisition is set aside earlier. Now, my lord, the climax comes then. This is Justice Lala. Then comes, my lord, another matter, my lord. Kindly turn to page 6.
Yes.
One Mr. Rungta belongs to the same area. He moved the writ application, challenging, my lord, the order of acquisition of his land. This matter, my lord, was taken up. My lord, the prayers of the writ application are set out under at page 6. We need not have trouble your lordship with the prayer. He challenged the order of acquisition. This matter, my lord, was taken up by Mrs. Kaur Gupta, my lord.
Is this the same acquisition case?
Same. Beg your lordship's pardon.
I-
Not the same land, same area.
But the
Covered by the same notification, covered by the.
that same acquisition.
Same acquisition.
Yes, same acquisition notification. Kindly turn, my lord, to page 7 bottom.
Yes.
Here also an affidavit in opposition. Now, the affidavit in opposition not by KMDA, but by the government of West Bengal. Deputy Secretary of the government of West Bengal. 21st November 2005.
Yes.
The purpose of the acquisition is set out page 8 top. Your lordship will find case number 27 here and 32, case number 27 and 32, page 8, 4th line from the top. Page 8, 4th line from the top, case number 27 and 32. Justice Shamunto was dealing with case number 27. That your lordship will kindly get, my lord. At page 4 bottom, Justice Shamunto was dealing with case number 27. Here, my lord, Justice Kaur Gupta was dealing with case number 27 and 32, covered with the same acquisition note. Now, my lord, before Justice Kaur Gupta, allegation was the acquisition was completed in accordance with law. This question came up, why? Because before any award could be made, my lord,
Yes, you're audible now. Yes.
Before Justice Kaur Gupta, it appeared there was a 4(1)A notification, same notification as in our case. But before any award could be made, the lapsing took place under section 7(A) of Act 2 of 48. Your lordship remembers, my lord, 7(A) was introduced in Act 2 of 48. Lapsing took place. My lord, Justice Kaur Gupta, before Justice Kaur Gupta, this question cropped up. They said that they have issued a notification under section 9, 3(A) and 3(B). Justice Kaur Gupta, here I have noted, kindly have a look at it. Ask them to produce the notification. That you have continued the proceeding after lapsing by issuing order notification under 93A, 93B produced. Now, my lord, kindly turn to this note sheet. Justice Corporal asked the lord. Kindly turn to page 8 bottom. Page 8 bottom. It's a quotation from the judgment of Justice Corporal.
Yes.
It is an admitted position that the notice under subsection 1 of section 3 of the West Bengal Land Common was issued in support of the said land on May 21, 1982. It is also not in dispute under subsection 1A of section 4 of the West Bengal Land Acquisition Act 1942 was also issued in respect of the said plots of land. It is also not in dispute that the acquisition proceeding in respect to said plot of land was not completed during the lifetime of the Act 1248. It is the case of the respondent that notice under section 3B of section 9 of the Land Acquisition Act was in respect to said land on August 26, 2008. On the basis of such notice, the proceeding was concluded in accordance with the provisions of the Land Acquisition Act. My lord, kindly have a look at your lordship members amended section 9 of the Land Acquisition Act. Lord 3A and
9(3)B, yes.
9(3)A and 9(3)B to provide for the continuation of the old proceeding after its lapsing on account of lapsing of the act or on account of 7A intervening and providing for lapse. 9(3)A and 9(3). Before Justice Corporal contended that there was a notice under 9(3)A, therefore the proceeding was continued and acquisition has been completed. Now, fifth line on the top at page 9. On the basis of such notice, the proceeding was concluded in accordance with provisions of the Land Acquisition Act 1980. Since the above claim of the respondent of issuing notice under subsection 3B of section 9 was disputed by the petitioner, the court directed the respondent authority to produce the copy of the record before this court. Pursuant to such direction, the records were produced to this court. The notices claimed to be issued under subsection 3B of section 9 of the Land Acquisition Act is quoted below. Now, my lord, his lordship is quoting. This is not a notice under section 9(3)B. This is a notice under section 9(3) of the original. You kindly recall the Land Acquisition Act, section 4 plus section 6 declaration. Then, thereafter, my lord, section 9 calling upon the persons to lodge their claim. This is the original section.
Yes.
This notice which they produce now is not 9(3)B, but 9(3) and 4 under the original act. This is not under 9(3)B or 9(3)A, but it is under 9(3) and 9(4). His lordship has quoted and then saying this notice is quoted. The notice is produced before the court. The notice is quoted. Then his lordship.
Sir, page 11, last paragraph.
Kindly turn, Lord, to page 11.
Yes.
I'm grateful to Mr. Pan. Kindly, Lord, turn. After perusing the provisions, kindly turn to page 11, last paragraph. Page 11, last one of the note.
Yes, yes.
After his lordship had gone through the notice produced, his lordship is recording. After going through the provisions of subsection 3B of section 9 of the Land Acquisition Act and the form of special notice to be issued under subsection 3 and subsection 4 of section 9 of the Land Acquisition Act 1894. The above notice cannot be claimed to be noticed under subsection 3B of section 9 of the Land Acquisition Act. Cannot be claimed. Therefore, I find that the proceeding under reference was not continued under the Land Acquisition Act. Not continued. Therefore, my lord, in our case, done to death with the High Court itself, quashed. In Jaiswal case, that is Lala quashed it. And here, my lord, his lordship has quashed the notice itself. It does not mean continued thereafter. This judgment of Justice Kaur was challenged below the division bench of Calcutta High Court. Your lordship will find, my lord, at page 12, last end, 21 to 2030. It goes to Chief Justice Girish Gupta's division bench. His lordship below, their lordships will affirm the view of Justice Court. 21 to 2030. Division bench affirms the judgment of Justice Kaur Gupta. Page 12, last paragraph.
Yes. Yes.
Appeal dismissed. Then it goes to the Supreme Court. The matter is taken to the Supreme Court. 4th July 2013. Supreme Court dismisses the special leave application. After that, I request the other authorities to issue a formal order of release. In your record, it's all recorded as acquired. Nothing of the kind. They maintain that notice under section 9.3 and 9.4 was in respect of a fresh acquisition. Kindly pause there for a moment. Mr. Pan, do you have a copy of the Land Acquisition Act 1894?
Sir.
Yes.
Kindly turn to section 9. Where originally there were subsections 3 and 4. In section 9, there are originally subsections 3 and 4. Original subsections 3 and 4 have been retained. Were retained. And two added subsections were there, 9.3a and 9.3b. 9.3a and 9.3b were in respect of the lapse proceeding under Act 2 of 48. Kindly have a look at 9.3a and 9.3b. They were introduced to maintain the continuity of lapse proceeding under Act 2 of 48. Well,
yes.
Now it has been found by the Honorable Single Judge Kaur the division bench, that there was no notice under 9.3a and 9.3b. They are producing under 9.3 and 9.4. Now they are falling back. They are falling back upon those notices under 9.3 and 9.4 as originally enacted. In order to be a valid notice under 9.3 and 9.4, there ought to have been a notification under original section 4 and original section 6. Forget about 9.3a, 9.3b. Forget, no amendment. Then 9.3 and 9.4 to be done only if there was a original notification under section 4. Kindly turn to section 4 and section 6 of the Act. First, initiation. Proposing to acquire under section 4, gazette notification. Unless there is a section 4 notification, then kindly turn to section 6 declaration.
without notification and declaration, six. Original 9.3 and 9.4 could not be there. They wanted to utilize 9.3 and 9.4, 9.3A and 9.3B. That was struck down. Now they said these are in respect of other original notification, original acquisition, no notification, no declaration.
স্যার এবারে রিট পিটিশনের অপোজিশনটা দেখাবেন স্টেট যেটা ফাইল করেছে
হ্যাঁ,
ওটা হচ্ছে স্যার সাব প্যারাগ্রাফ এফ
তুই পড়ে দে। Mr. Pan will kindly read out, my lord.
sub paragraph, my lord, kindly have a look at the, my lord, the affidavit in opposition filed to in connection with the writ petition by the state.
Respondent number 12678.
State respondent number 12678 and 9. This is the affidavit filed on behalf of the state. Tarok Mulli, yes. Now kindly turn to, my lord, just page 5, subparagraph F. It is a fact that the collector, Howrah, issued a notice in exercise of the provision incorporated in the Act 1 of 1894 on January 22nd, 2004 under subsection 3 and 4 of section 9 of Act 1 of 1894 regarding plots in question being involved in case number 29-1 of 1984-85. With regard to such land in question, which also includes the land which the writ petitioner allegedly claimed to such land in the purported writ petition. My learned senior, Mr. Mukherjee has submitted.
There is no notification under section 4.
Section 4 and section 6. Now, my lord, kindly turn to, sir, arekta paragraph dekhiye debo.
You kindly proceed, Mr. Pan.
Yes, yes, arekta kindly turn to paragraph page 8, paragraph 10. MD is saying something else. Can I kindly turn to page 8, paragraph 10. With reference, your lordship has got it. With reference to the contents made in paragraph number 11 and 12 of the said purported petition, I deny and dispute each and every allegation made therein, 7 except those which are matter of records. If anything be stated therein which is contrary to the records, the same is deemed to have been denied in seriatim. It is a fact that the then Honorable Justice Probir Kumar Samanto, in his order dated 29th April 1997, in SHIO number such and such, while disposing of the said writ application, did not prevent the respondent authorities at that point of time to proceed in accordance with the provision of law for the purpose of acquisition of the lands in question of the writ petitioner therein, and accordingly, the state respondent herein have proceeded such acquisition proceeding afresh by invocation of the provisions incorporated under Act 1 of 1894, and such process was complete in terms of law, and award was made in connection with the said acquisition proceeding involving the plots in question as mentioned in this purported writ petition. Next, with reference to I deny and dispute each and every aggression made therein. I say that the plots in question and as stated above being involved in LA proceeding number Roman 2, 29 and 84 had been converted into a proceeding under Act 1 and award was passed. Then kindly, well, next Mallard, kindly turn to Mallard next paragraph 13, page 10. I say that the lands in question are stated above as claimed by the writ petitioner under no circumstance can seek for passing a formal order of deed acquisition in respect of the said land, since those land in question as stated above are already been vested to the state of West Bengal as the material point of time in terms of the law as per records. I further say, as per records, award was passed in respect of the respective awardees concerning the land in question RS Dagna such and such in connection with LA case number 299, 29, 86, 87. One time they are saying 84, 85 award has been passed. Now this time they are saying 86, 87.
Now, madam, Mr. Mukherjee will continue further. Sir, bolun sir.
My lord, Act 2 of 48 proceeding admittedly quashed. That is not disputed. If there is to be a proceeding under Act 1 of 1897, fresh. Act 1 of 1894, fresh proceeding. It is to commence with a notification under Section 4 and a declaration under Section 7. Those notifications or declarations provide a foundation for a fresh proceeding. Compensation is to be awarded with reference to the date of the notification under Section 4. Kindly produce the notification and declaration. They're all gazette notifications. By merely asserting there was a conversion of the earlier proceeding into a fresh proceeding. No notification has been produced, no declaration has been produced. They produced a notice under 9.3 and 9.4 and wanted to pass it off at 9.3A and 9.3B, which was struck down in the earlier case. Thereafter, before that, no proceeding under Section 4 or 6. A notice was there under 4.1A, which was struck down by Mr. Supergroup. How can the declaration be all? How can there be a 9.3, 9.4? The old notice they are utilizing for the purpose of showing as if there was a fresh acquisition. No notification, no declaration has yet been produced in court. Therefore, my submission is acquisition under Section Article 308 can a person can be deprived of his property only under the authority of law. The law says either for Act 2 of 48 or under Act 1 of 1894. And there's a prescribed mode. The mode is to be strictly followed. Acquisition law is to be strictly followed. Without following the prescribed mode, you cannot acquire. No notice under 4, no declaration under Section 6. They still say have acquired. My prayer before Lordship is that kindly direct them in accordance with the judgment of Prabir Kumar Shamant and the judgment of the Court Group to issue an order of release, and my property has not been really acquired. That's all. For the
আরেকটা প্যারাগ্রাফ স্যার পেজ 8 প্যারাগ্রাফ 8 টা একবার পড়ে দেবো যেখানে ওরা কন্ট্রাডিক্ট করেছে স্যার
পড়ে দিন
হ্যাঁ স্যার Malord, can you turn to paragraph 8 of page 8 of the same opposition? One hand, I just shown to your Lordship, Malord, that it is in respect of 84, 85. They are admitting. Now, in this paragraph, what they are saying, that I deny and dispute each and every allegation made therein, 7 except those are which are matter of records. I say that the vast area of land within Mauja, Pakuria, including the lands in question as stated above, which is requisition for West Howrah Development Project under the provision of Act 2 was in relation to LA case number 8687 and not under the LA case number as alleged. And the fact remains that the LA case number 8687 involved in the plots and mentioned was complete proceeding was in terms of self-contradictory statement.
My lord, this LA cases are departmental numbers. Gazette notification has its own number. Gazette notification is the parent notification. Under that parent notification, with reference to different individual claimants, different LA cases are started. There is one parent declaration, notification, and with reference to individual claimants, LA cases are started for payment of compensation. I wanted to know, after 4.1A being struck down, after holding that my land was not acquired because there was no order of acquisition, any fresh order in respect of my land, anywhere, only saying case number such and case number such and such, that will not bring about acquisition. You have to produce a notification as well as a declaration. None has been produced.
স্যার আরেকটা পেজ আমি দেখাতে চাইছি জজ সাহেবকে স্যার এই এফিডেভিট রিপ্লাই টু দ্য কেএমডিএ আমরা যেটা ফাইল করেছি পেজ 46
দেখিয়ে দিই জজ সাহেব দেখিয়ে দিই
হ্যাঁ মানে কাইন্ডলি টার্ন টু আওয়ার রিপ্লাই টু দ্য মানে দ্য এফিডেভিট রিপ্লাই টু দ্য রেসপন্ডেন্ট নাম্বার 11
ওটা একটু নোট করে দেবো রে তবে শুরু
হ্যাঁ আমি দিয়ে দেবো পরে আমরা নোট
করে দেবো জজ সাহেবের লিখে রাখা সম্ভব
হ্যাঁ হ্যাঁ our reply to the affidavit in opposition filed by the KMDA, respondent number 11. No, respondent number 3, 4, and 5. Respondent number 3, 4, and 5. KMDA, 3, 4, and 5.
Now, Lordship, kindly turn to page 46, annexure P18. This is the affidavit opposition
KMDA.
filed by the KMDA in a proceeding pending before Justice Samanto. Your Lordship, in the judgment, they have referred to this affidavit. In this affidavit, kindly have a look at this. This is in connection with LA case number 27 of 1884-85. Now they are using this affidavit. Yes, that is, my lord, at page 46. I am the Deputy Secretary of the respondent number 6, Calcutta Metropolitan Development Authority. Now, he is referring, he has not denied that about the proceeding. There, kindly turn to paragraph 9. Since the land of the petitioner has acquired in relation to the West Howrah Township project, the same project they are referring to. Paragraph 9.
Page 50.
At page 49. At page 49, my lord, they are referring to the same project in connection with the proceeding LA case number 27 of 1894, 84-85. Then, Lordship, kindly turn to
Not find this sentence in this page.
inner page 4 of the opposition. 4, paragraph 9. Oh, paragraph 7. It should be 7 or 8. Seven. There is a reflection of the West Howrah New Township project they are referring to. West Howrah Township project. Yes. Next, kindly turn to, my lord, the next page, my lord, at page 51, inner page, my lord, 6. Now, this is the notification they are referring to published in connection with the section 27, LA case number 27. Because in this affidavit, they are saying that notification number 9262 of dated 4th February 1989.
This is LA case 27.
LA case number 27. Because this is in connection with the writ petition filed in connection with section LA case number 27. Then, my lord, one more.
Paragraph 12, paragraph 12.
Paragraph 12.
Parent notification is referred to.
Yes.
Parent notification. That is 418.
Yes.
9252.
Paragraph 12 you've just read out.
Paragraph 12 of this affidavit at page 51.
Yes. Paragraph 12. Yes.
I deny this.
Yes. Paragraph 12, my lord.
You've just referred to.
Yes. Just refer. Sir, আমি এইমাত্র দেখালাম.
Oh, acha. Okay. I'm sorry.
Just refer to this is the notification which has been quashed by the Justice Samanto. And they are saying, pursuant to the leave granted by Justice Samanto, they issued a fresh proceeding without section 4, without section 6, straight with the section 9. Sir, bolun.
আমার আর কিছু বলবেন না, let them
ঠিক আছে
let them give the reply. I will then thereafter give my reply.
Yes. And we also, my lord, file a short note for your lordship, my lord.
After their submission.
Yes. Sir, sir. মানে কি গান্ধী না বল
Now, who will make the
Now the state.
If the state complete its argument, then we'll.
Will come. Then
where is the state?
then me.
State, nobody is
very reluctant. Very reluctant.
Who is appearing for the state in this one?
Sushomon Sendu is advocate general, I understand.
Lordship.
It's appearing.
Yes,
Yes, Mr.
We
D.
have been informed.
Sir?
AG will be appearing.
AG will be appearing.
Please you.
So let there be another date, let the state come.
Let-
So will you please inform the state? Because
Madam,
do not
I will,
see it.
I will. Tomorrow itself I will. I will serve him a notice.
Come back.
This side of vacation, madam, kindly. At 3:30, this side of vacation.
Cannot come.
Yes, madam, let it proceed with me. Madam, let it proceed with, at least one day, madam.
We lose continuity. Come back immediately after the issue so that we can complete the matter. The issue is not very complex.
Yes.
Whatever Mr. Basu might
No, I am the last person to say anything. I am the beneficiary of the deed.
made complex. So,
Yes.
let us deal with the matter immediately after vacation, so that it can be concluded.
My
Sir,
lord,
shall we come back after vacation? Otherwise, we lose continuity.
Lord, if there is a change in determination, I will be resumed.
no, part hard হয়ে আছে, স্যার, এটা part hard হয়ে আছে।
Oh, all right.
হ্যাঁ, hard in part। কেন সেদিন কিন্তু একসাথে ছিলাম।
This may not be so simple as has been placed. So let us.
So very difficult, you kindly deal with the
We
difficulty.
will go by the record.
Certainly.
Under the same ruling. 7 June,
My lord, 3:30, my lord, kindly make it
June, sir.
8 rules.
7 June, after we do.
3:30. And already hard in part, my lord.
That is all.
Why we are here? To make the simple thing complicated.
I wish I could record it.
Yes. part hard আছে, আগের দিনই part hard হয়ে গেছে।
আবার পাঠান করো।
দুবার করে part hard হয়নি।
I'll just check.
Yes, my lord.
So the petitioner submission is concluded. Let it be recorded.
স্টেটকে ধরে নিয়ে স্টেটকে
Let it be recorded that they have completed their.
আপনারা বলার পরে বলবো
Reply to them.
Third and fourth.
Hard in part.
আমাদের অসুবিধা নেই Sir, যদি আবার বলতে চান বলবেন।
On the last occasion, it was noticed.
Yes, yes.
আর যদি বেঞ্চ চেঞ্জ হয়ে বাইরের যে ডিভিশন বেঞ্চে চলে যান কি হবে?
দেখা যাবে।
মেনশন করে আনা হবে।